Yes.
If Lordship recalls, item number 9, we had the occasion to argue across, madam. But may not be pleased to take up the matter. Item number 9.
9.
In the writ appellate statement, Lordship was there on the other side.
Oh, yes.
After vacation,
Mr. Esboni Glennet, Senior Counsel, assisted by? And?
no, he's not there.
Oh, he's not there. Full stop. Place this matter before a bench without me.
Wait for Lordship. Right.
Yes.
Item number 33, madam.
33. Learned Counsel appearing for the petitioner has submitted that the matter has become infructuous and therefore the same may be closed without further adjudication. Full stop. Accordingly, the matter is closed.
Obliged, madam.
May I plead your Lordship, with the consent of the petitioner, I beg to mention item number 7, Lordship.
7.
7. I am the respondent number 5, Lordship. So I am about to file exclusively in opposition, Lordship. Can they allow me some time when agenda may not today, Lordship?
At the request of your name,
8 after.
Ms. A. Talukdar, Learned Counsel appearing for the respondent number 5 and with the consent of the Learned Counsel for the petitioner. Place this matter again on? Yes, after vacation. On so and so date, allowing her to file an affidavit in opposition. Yes.
I'm for the petitioner, Lordship. Public.
Release admission, item 1 and 2.
Yes. What is this matter, sir?
Last occasion.
Huh?
Last occasion also done.
Have you gone through the file? Have you gone through the file?
Yes.
There appears to be a stay in the matter.
Yes, Lordship.
He has been found guilty.
Yes.
There is a stay in the matter. But দুখন ৰিট আছে নেকি ইয়াৰ লগত? একেলগে দুখন ৰিট আছে ন? Have you seen the notings? There is a
Prosecution.
huh? No.
Item 1.
There was a DP held against this man.
Yes, Lordship.
Then second show cause notice was issued to him.
Yes, second.
He got a stay from this court. And your respondents have not made any move to have the stay vacated. Hmm? Huh? Prosecution sanction has been granted.
Yes.
What has happened to the final report? What has happened to the final form?
His lordship, appointment from lordship,
Get us a senior government advocate or the additional advocate general. Ask him to go through the file. Tell us what the government intends to do. Protect this man?
no, lordship.
Do what?
So we will file that.
When no. Get us someone. Get us some person who can go through the file and tell us.
Item 3. Yes.
After some time, do. After some time.
Item 4. Item 4.
Pending council education. AD Duke. Square Duke.
Item 5. Item 5. Item 5. Item 6.
Make me the respondents have not filed their affidavits, Lordship, in this matter. Lordship, and this particular matter with other two read petitions, Lordship, as per Honorable Court's order dated 3/6/2026, in another read petition, Lordship, it was fixed for 15/7/2026, Lordship. Three read petitions together. Somehow, Lordship.
They're tagged together.
Lordship. There's another read petition, Lordship. Till now, it has not been tagged, Lordship. Order was that the three matters should come up together.
When was the, in which case was that order?
Lordship, that is WPC 4426.
Direction? WPC 4426 order dated?
Order dated, Lordship, 3/6/2026.
Order to direction copy. After
Meanwhile,
some time, we'll take that.
Lordship.
We'll take that order in hand, we'll see what is.
Lord.
Item 8.
That this batch,
Lordship, some more time is equal to file the.
this batch is listed minutes.
Hmm.
This batch is listed minutes pursuant to the order if your lordships have minutes. In item number. That is, Pallavi Sharma is item number. In item number 21, 22.
Hmm.
No, yeah. What is the item today? 21. Pallavi Sharma, madam. This matter was listed on
Item 21.
Friday last. That's Surandita's order. My lords have 19th March, June order, my lord.
Hmm. Yes.
Interim orders, my lord, state the discharge orders, but we have not been allowed to join. So that's what, my lord, was a matter of concern for.
Who appeared on the occasion? Kindly have Mr. Dinath here because the last order of 19/6 says that you are to inform this court whether the interim order has been complied with. If not complied with, we shall have to see what is to be done.
My lords, may I just make one submission? My lords,
Yes.
I'm assisting Mr. N. Kohli. He's appearing for the state. He logged in through VC, my lords. He will address arguments, my lords. May kindly allow, court master may kindly allow his entry, my lords. In Zoom, he's.
I think it has been allowed, no?
We have been allowed. I'm told he's not allowed, my lords. Or my lords, may pass it over.
Item 18.
May pass
Waiting
it
room
over.
চক এটো কেলে allowed মানে উপর waiting room to চক আৰু উপৰলে ও ৰাম waiting room 1 হৈ আছে
Now he's there, my lords.
Lordship, I'm online. I was waiting in the lobby. I'm sorry.
yes sir
I'm so obliged, Lordship. We have also prepared a note, but I think my learned friend may make some opening comments. Then, Lordship,
no,
I'll
he
assist.
just
Lordship.
he wanted us to go through that order of 19/6
Yes, Lordship. So
where we
we
were
have a
required to be
3-page thing,
informed.
Lordship, because in effect, what he's asking is for, we'd like to point out that how we have to look at 141(1), Roman 1 of Lordship Barua's judgment. Has to be read with 141(7). And what my learned friend is seeking would amount to the interim prayer, the final prayer being given at the interim stage. So if Lordship would permit, we have a short 2-page note, 3-page note. Can we share that with Lordship?
Please do.
My colleague should be there in court, Lordship. Ankit?
Yes, sir. Munmi madam is handing over. Note.
And one perhaps to the other side also, my friend Arna. So if Lordship, basically just para 1, we have just simply pointed out that my learned friend is seeking the quashing of that impugned notification, Lordship. In terms of the compliance, we are saying that discharge has been issued in compliance of para 141 Roman 2, read with para 141 Roman 7. So if Lordship may just for a moment come down to our para 2, we have reproduced.
Where is that order? Where is that notification of 21/7?
Lordship, that is in his writ petition itself, Lordship.
Where is it?
I'll
That
just
is
give
page
Lordship.
66, my lord.
Page
66.
66, Lordship.
My lords have that Pallavi Sharma. Yes, page 66.
Yes, Lordship. Annexure A, 68.
Pallavi Sharma, page 66 is
No,
the
88,
prayer
68,
clause.
Lordship.
Yeah, that's
68.
the discharge order, my lord.
68.
So would Lordship permit me to read that?
Just a minute. You can read. You can read.
Yes. Whereas in compliance of the directions at para 141 Roman 2, read with para 141 Roman 7, passed by the Honorable Gauhati High Court, dated so-and-so and writ petition so-and-so, and other linked matters, the Governor of Assam is pleased to withdraw the government order of discharging Srimati Pallavi Sharma Chaudhary from Assam Civil Service by day notification so-and-so, dated so-and-so. This is the 2018 notification, Lordship. And whereas,
26.
as directed by the Honorable High Court, the case of Srimati Pallavi Sharma Chaudhary, who was on probation in Assam Civil Service at the time of discharge, vide notification number. This is dated 26/2018, which is the original first discharge order, is considered, and upon consideration, she is not found fit for confirmation and being a member of the Assam Civil Service. Now, therefore, the Governor of Assam, in exercise of the powers conferred under to Rule 20C of the Assam Civil Service Rules 1998, is pleased to discharge Srimati Pallavi Sharma Chaudhary, ACS probationer, from service with effect from 26/2018. That is the date of discharge given by a notification dated number so and so, which stands substituted as directed by the Honorable Gauhati High Court. So the substituted lordship is in para 1, which is referring to para 141 Roman 2, read with para 141 Roman 7.
Where is the direction of the writ appeal?
Now, if lordship would be pleased to come to the note for hearing that we have just submitted to lordship. And if lordship would be pleased to take para 2 of that note. There, lordship may just see we have reproduced para 140. So I'm reading it. Para 140 says, accordingly, the appeal is partly allowed by setting aside the impugned judgment and order dated 18/3/20, passed by the learned single judge in writ petition 4198 of 19 and 48 connected writ petitions. Resultantly, the appellants are found entitled to the following reliefs. And 1, the discharge orders in respect of all the appellants herein, which have been impugned in the connected writ petitions, namely writ petition 4198 of 19 and the 48 connected writ petitions, are set aside. The next sentence is important. However, this relief is subject to the following. So therefore, the relief is conditioned on the following directions which follow from Roman 1 to 8. Now, lordship may see 1, Roman 1. Those appellants who have completed their initial probation period of 2 years, and by taking into consideration the maximum extendable probation period under the respective rules, then lordship may come 3 sentences below, are liable to be reinstated within a period of 50 days from the date of this judgment and order. Pause. Therefore, the judgment says, after considering all the rules, service rules, that the person or the petitioner must complete 2 years of the initial probation period, as also take into consideration the maximum probation period permitted under the rules. It is a matter of fact that the petitioners herein have under their rules have a period of probation which is 2 + 2 equal to 4 years. So therefore, we have to consider whether they completed the full 4 years or not. Why? Because lordship, the settled law on this, which is also part of the judgment, is essentially that if their prescribed rules permit an extension of the probation after the initial period of probation is over, there can be no deemed confirmation in the service. On the contrary, there will be a deemed extension of the probation. That is the law. Now, lordship, let's read 2. For those appellants whose period of probation have not been completed, by taking into consideration the initial probation period and the maximum extendable probation period under the respective service rules referred herein above, the competent authorities are directed to pass such appropriate orders as may be deemed fit and appropriate, considering the finding rendered in this judgment and order, as well as by taking into account all the relevant factors as may be permissible in law. This exercise shall be done by the competent authorities of the respective departments within a period of 50 days. So 2 makes it very clear that A, if your probation is not completed after the initial period of 2 years and also the extended period of 2 years, then the competent authorities, being the government, may pass appropriate orders as deemed fit. Therefore, number 7, Roman 7 becomes most important. If there are any appellants whose probation period has not been completed, i.e., initial probation of 2 years plus 2 years extended probation, they would not become entitled to be reinstated in service. Therefore, the direction is clear, unequivocal, that if any person has not completed the full 4 years, 2 + 2, they are not entitled to be reinstated in service. However, in respect of those appellants, the competent authorities and the government shall pass appropriate orders to withdraw their respective discharge order already passed and to substitute the said discharge orders with a simpliciter discharge order of not having them fit for confirmation, so no stigma be attached. Therefore, the impugned notification at page 68 of this petition is passed in compliance of 141 Roman 2, read with 141 Roman 7. Because our case is that this petitioner and the other petitioners are
On which,
covered
in
squarely.
which category does this petitioner fall?
7. I will show next. I'm
7.
coming there. Yes, Lordship, I will show it. Please see para 3. And I've drawn a chart, Lordship, for your consideration and easy reference. The petitioners governed by Rule 22 of the ACS Rules 98. That is, Lordship, at page 233. Rules provide exactly what it is, that initial period of 2 years, which may be extended for a further period of 2 years. Please note the dates in the chart. Appointment date, Lordship, was 12/8/2015, which is for 2 years probation. That initial probation ended on 11/8/2017, Lordship. The date of extension of the probation was 27/11/17. And I've already said, Lordship, it is settled law that there can be no deemed confirmation at the end of the initial 2 years. So therefore, it was extended on 27/11/2017. The date of discharge was 26 June 2018. And the extended probation period would have gone to 26 2019, i.e., the person, in this case, the petitioner, would have completed 4 years, 2 years initial, plus 2 years extended on 26/11/19. And this person was discharged prior to the completion of the total 4 years. Hence, let us go back to the previous paragraph and read Roman 7 of the judgment.
Why does she not fall? Why does she not fall in Roman 2?
Lordship, I'll come back to Roman 2. I'm grateful for that question, Lordship. Please note that Roman 2 also says the same thing, not so specifically. For those appellants whose period of probation have not been completed in what terms? By taking into consideration the initial probation period, and it is not or, it is and initial plus the maximum extendable probation period under the rules. So 2, according to us, respectfully, and 7 say the same thing with regard to the relief. You will get the relief only if you are completing 2 plus 2. And 7 makes it clear, if you have not completed 2 plus 2, you are not entitled. So I would say respectfully, Lordship, they are two sides of the same coin. One says you are entitled if you complete 2 plus 2. 7 says you are not entitled if you have not completed 2 plus 2. I hope, Lordship, I have made that clear. Now, Lordship, may come to para 4 of our note at the top of page 3. We have just given the explanation. As per the directions in paragraph 141 Roman 2 of the impugned judgment, for being eligible for reinstatement, the petitioner is required to have completed both the initial 2 years probation as well as the 2 years maximum extendable probation period, i.e. completed 4 years. As is evident from the table above, the petitioner was discharged from service on 26/18, i.e. after completing the 2 years initial probation period, but before
just tell us one thing, Mr. Kohli, just tell us one thing.
Lordship.
The notification at page 68 has been kept in abeyance. You shall not give effect to the same.
Yes.
Yes, Lordship.
Yes, rightly or wrongly, you will not give effect to the same.
Lordship.
So what is the result of not giving effect to the same?
I'm grateful for that question. Would Lordship please come to para number 5 and the heading above it? The heading above para number 5 of my note.
Whether we are allowing a reinstatement now is now or not, that will be another issue. We'll be arguing on the correctness of the interim order. We want to know the effect of the interim order.
Lordship, basically the person concerned here, and that would
when
be
we
clear,
say something is not to be given effect to,
yes, Lordship,
it does not exist for the time being, is what we understand.
Lordship,
now without this, what is the effect?
Yes, Lordship. May I just assist Lordship on that specific query that
Hmm.
flowed from the bench? Lordship, even in the judgment which is being considered of Justice Barua, the coordinate bench, this aspect came up that there were prior orders passed by a coordinate bench staying the DP. Now, Lordship may just bear this in mind. Effectively, I'm sorry, this was Justice Surana's DB. I beg your pardon, I made an error, Lordship.
We'll take
The
it to be
point
one
was-
court. You just tell us
Yes,
the,
please.
we need not go by the person concerned who was passing the
I'm
order.
aware.
We'll go by
Wait,
the High Court passing an
wait.
order.
Yes, Lordship. So the
Yes, sir.
Honorable
Which
High-
order were you referring to?
I'm just coming, Lordship, in another batch of petitioners before this honorable court. What had happened is that the DPs had been initiated, and the coordinate bench of this court passed an order staying the DPs.
Hmm.
When that order was passed, which was of January of 25, the
Hmm.
reinstatement was ordered.
Hmm.
That eventually the state filed vacation of stay applications, urging this court to consider on the settled law that reinstatement would amount to giving the final relief at the interim stage.
Hmm.
Those were pending consideration.
Hmm.
And then finally, the court decided instead of going into the vacation applications, we will go completely on the final hearing. And then the final hearing took place.
Are they
So
listed
therefore,
before this court today?
No, no,
Those
that's-
matters?
No. I'm pointing a coordinate bench issue. That is a separate. That's why Lordship is giving the names of the court. But I will
Ah,
stay with what flowed.
it's
That's
all
the
right.
correct approach. So
We go
therefore,
by the
Lordship,
roster.
yes, Lordship. So therefore, the point we are saying is that the current petitioner is not in service for 9 years.
Hmm.
The petitioner stands discharged with effect from 8/11/2017.
Hmm.
Lordship, now there are two aspects to Lordship's past order. The first is the discharge, the fresh discharge has been stated. In effect, the person was not in service on the day of the discharge. So therefore, there cannot be a plea of reinstatement
No,
because
once the discharge order is set aside, thereafter you are given liberty to do certain more things. Yes, that is how I understand
Lord-
it.
Yes,
The
Lordship, that is correct.
discharge order is set aside, but the discharge will be subject to following things that you are permitted to do.
Right, Lordship?
Now, for those who had completed probation, they will stand reinstated. And whatever else you are required to do under for 55 or whatever, what was that?
140. Lordship,
Within a
140.
50 days of 50 days, they would have to be reinstated.
Yes, Lordship.
Those who did not complete 40 days, you would be required to pass orders on them. Therefore,
May I assist, Lordship? I've understood what is flowing.
yes.
Lordship, may I assist?
Mhm.
So there are two aspects. Lordship, there are two aspects to what is flowing. And if Lordship would bear with me for a minute.
Mm.
Lordship, the first is, as Lordship is quite correctly pointing out, that there was a discharge order originally. That discharge order was upheld by the single judge. That discharge order is set aside by the learned DB of the court. That learned DB, while passing the final directions in para 140, lays down the norms of giving benefit. Let's pause. The petitioners herein, it is the state's case, as also the vast majority of all these petitioners, all of them, they do not fall into para 142 or 7. They can't get the relief of reinstatement, which is the final adjudication, because they are not eligible. They are not eligible at the threshold for not having completed the 4 years total probation. That is what the effect of the judgment of the DB is. Now let us come to the second discharge order. Without prejudice to the fact that the DB's directions we have implemented the DB directions. Part A of that direction is whether the person is eligible or not. After looking at the directions, the second discharge comes. Lordships have stayed that discharge, but that does not give them the eligibility to be reinstated because that would be violating the directions of the DB's order itself because they never completed 4 years. That's the argument.
Yes, where do you find a reinstatement in your service from?
Yes, madam.
For those who had completed 4 years,
Yes, madam. May I just,
specific direction to be reinstated.
madam, may I just,
So
For
sorry,
the others,
Lordship,
orders
I
are
don't
required to be
my,
passed.
my friend has
sorry,
selected.
I don't want to sorry, just one sentence to close this, Lordship. I don't want to interrupt. Just to assist Lordship on this. Therefore, Lordship,
Para 55
my
no?
learned friend would have to first establish in 140 Roman 1-2 that they had completed their 4 years before he can ask for reinstatement. I'm over with my this. Grateful, Lordship.
Okay.
Malad, firstly, Malad, what my friend has argued today, there is already a detailed interim order of your Lordship's court on 28 August 2025 and other dates, my lords, of the other petitioners herein, where, my lords, the discharge order of 21st July 2025 has been stayed. Shall not be given effect to, in my respectful submission, is a stay of the discharge order. So it is not open for my friend today to say that I fall in 141(1), so 2 + 2 equal to 4 years. My case, my lords, is, and I will place the division bench judgment of this court. Division bench held, my lords, that the period of probation under the rules is 2 years, extendable by a period of 2 years. Division bench holds that by the time the petitioners were, the appellants were discharged, they had completed their normal tenure of probation of 2 years. It's a finding, my lords, finding. Division bench holds that these discharge orders are punitive and stigmatic. So, benefit of Article 311(2) is available.
That is.
So departmental. That's why your lordship said,
no,
why will they not fall in 141(2)? Right, my lord? Division bench also held that there is no dispensation of inquiry under the second proviso of Article 311(2). That, my lord, it is impracticable to hold the inquiry. Court went to the record.
We've seen that.
So then court says, my lords, also finds that they were given regular postings, they were given substantive post to occupy, they were given second increments which are available only to a confirmed employee, and court held, my lords, on the finding of fact in the petitioners before your lordships that they are entitled, my lords, to be reinstated in service. My friend is now please come, my lords, to 130, first paragraph 138.
Of the
First, my lord, will your lordships have para 55 of the petition, where my friend was reading from the note. And this exactly, my lord, is considered by the single judge by a detailed hearing, and an order is passed.
Para 55.
Whether it amounts to grant of a final, page 237, running page 237. Whether it amounts to grant of a final relief, my lord, is not open to my friend today to argue, my lord. Without an application for vacation of stay, without, my lords, a reply file. Your lordships have para 150, para 55, my lord. Running page 237 of the judgment. My lords, Thus, from the above, when all the rules are analyzed, it is seen that in all the 4 service rules, except under the Assam Police Service rules, the period of probation is 2 years, which is extendable to a further period of 2 years, however, with some variation in language in the said rules. Insofar as Assam Police Service is concerned, there is no upper limit for the extension. Right, my lords? Now, my lords, please come to paragraph 138, 6. Page 290.
Just a minute.
Running page 290. Paragraph 138, 6, my lords, Yes. The learned single judge has failed to consider the relevant provisions of confirmation of a probationer as laid down in the respective service rules for the appellants, because except for the Assam Police Service, all other applicable services rules envisages a probation period of 2 years, extendable as provided therein, and therefore by the time the appellants were discharged from service, they had already completed the normal tenure of probation. Therefore, the appropriate government will have to take a decision in terms of the applicable rules as to which of the appellants have not completed the period of probation. So there's a finding, my lords, by the division bench that by the time they were discharged, we had completed the normal tenure of probation. Right, my lords? Now, my lords, please also come to 292. Relying on Purushottam Lal Dhingra, subpara 9 of 138, my lords, have that. In light of the various decisions of the Supreme Court as discussed herein above, wherein it has been held that the protection of Article 311(2) was available also to a probationer, and in the light of the fact that nothing was placed on record to show that the authorities have passed any specific orders as required under Clause B of second proviso to Article 311(2), the reliance on the decision of the Supreme Court in Palak Modi is not sustainable. Article 311 does not create any distinction between a confirmed regular service employee.
Now, once the court holds that all the appellants had
Completed
completed their
period of probation.
period of probation, why this 1 and 2, that 1, 2 and 7, the
Yes.
differentiation?
Now, my lords, please, before that, will your lordships also come to running page 271?
Hmm?
Running page 271. Just to conclude, my lords, what are the findings of the division bench? Para 111. My lords, sir.
Hmm.
Therefore, even assuming that the appellants were probationers, yet when the discharge order is based on foundational facts and the materials available against them was not the motive to pass discharge order against the appellants are found entitled to the protection envisaged under Article 311 of the Constitution of India. In this case, the government has not recorded its satisfaction in writing as to why it is not reasonably practicable to hold such inquiry. Clause B to second proviso to Article 311(2) is an exception and not a rule, and therefore the same must be scrupulously followed, which was not done in this case, which is found, please mark, my lords, to vitiate all the discharge orders. So it covers, my lords, the petitioners, all the appellants. Then, my lords, 112. This is not a case where the appropriate government had taken a decision that in the light of the allegations against the appellant, they are not found suitable for extension of their probation. At least no such decision was placed during the course of hearing of the batch of writ petitions, wherein the judgments impugned in this appeal were passed. Then it could have become a motive and not the foundation. Only thereafter question could have arisen as to whether the period of probation of the appellants under different service rules would be continuing or the probation period was over and the principles of deemed confirmation would apply. At this stage, said issue appears to be academic. Then 113. In this case, there is nothing in the impugned judgment that the competent authority of the state has passed an order to dispense with the inquiry in a manner as envisaged under proviso B to second provisos. Therefore, it has to be presumed, please mark, my lords, that the appropriate government has not passed any order to record its satisfaction in terms of sub-rule 2. Now, my lords, please come to, my lords, page 284.
No, let me read it once again.
Which part, my lords?
112. This is not a case where the appropriate government had taken a decision in the light of allegation against the appellants, that in the light of allegations, they are not found suitable for extension. At least no such decision was placed during the course of hearing. Then it could become a motive and not the foundation. Only thereafter question would have arisen as to whether the period of probation of the appellants under different continuing or the period or the probation period was over, and the principle of deemed confirmation would apply. Even assuming the reference of provisions at the discharge order was issued. Has the state filed affidavits in these matters?
No.
Why not?
That's what my lords led my lords to their lordship's court on Friday.
You are not audible, sir.
Since August, they have not filed. They have not complied with the order.
Lordship, in fairness, I have something to say. On 20th of August, the order, Lordship, may just for a moment come. It clearly says in para 10 will not be given effect to. There's no blanket stay. Number 2, the writ petition has been amended and that was allowed on the 21st of May 2026.
Okay.
This is the first date after the amended petition has come. Lordship, I can't be taken back to August last year when my learned friend has
understood.
changed
If it is may understood. If it is may understood.
Reply.
Now, my lords, please.
You were referring to page 100. We were referring to para 111 and 112.
Yes,
Thereafter,
113 also, my lords.
Thereafter, you wanted me to go to page 290?
284, my lord.
284.
Yes.
Okay.
My lord, sir. I'm reading, my lord, just above the quotation part, my lord, para 129. Therefore, in the present case, my lord, sir, the service of the appellants was terminated as a measure of punishment. It has been held that the discharge of the appellant was not by way of simplicity of discharge. And then it quotes, my lords. And then, my lords, your lordships will come to para 138 at page 287. So the findings, my lords, are at para 138. Running page 287. In the light of the discussions above, court is inclined to hold as follows. My lords, have that? Lordships will skip the first and second. Come to number 3, my lords. The learned single judge failed to appreciate that the competent authorities of the state respondent had not passed an order envisaged under Proviso B to second proviso of Article 311(2), which requires that when an authority empowered to dismiss or remove a person or reduce in rank is satisfied, some reason to be recorded. Then please have number 5. As the reasons to terminate the appellants according to the impugned judgment is the participation of the appellants in colossal fraud, the learned single judge has failed to take into consideration that the termination of the appellants through projected to be probationers, in substance represents a penalty imposed on the appellants and no punitive action taken against them. And as such an action has been held by the Supreme Court of India in para 13 of the case of Motiram Deka, decided by a special bench of 7 judges to attract Article 311(2) for the termination removal. Moreover, it was further held Article 311 makes no distinction between permanent and temporary employees. The same is found to vitiate the impugned judgment. So the court says, my lords, I am entitled to the protection under 311(2). Now, my lords, please have page 292.
No, then this finding of the
Division bench
that everybody had completed their period of probation
of 2 years.
of 2 years.
Yeah.
Now, whether the extendable time was required to be done or not, that was left out as an academic exercise.
Yes. Court
They are
said,
trying to
because they have not taken, because after you conclude 2 years, they have to take a decision. There is no extension. So they continued, my lords. Court found
they continued as what?
Court says, findings are that they were treated as confirmed employees, as regular employees. They were given second pay increments. They were given substantive post to hold in a regular posting. So these are findings of the division.
So, and the government now tries to say that no, since there was no extension, there is no question of a deemed extension, therefore.
Yes. Deemed extension.
There is no question of a deemed confirmation, therefore it's a deemed extension and therefore we can pass an order like this.
Assuming that
that is what they are trying to say.
Correct, your lordship says, then to pass an order like this means what? My status was what? As that of a probationer? Court says Article 311(2) protection is also available to a probationer, relying on Motiram Deka's case. Court said that the single judge.
That is to the extent whether they were required to form an opinion as to whether 311
that happened was, my lord,
not necessary to hold an inquiry or not possible to hold an inquiry was required or not. It is to that extent.
My lords, the discharge orders there were passed simpliciter without an inquiry. No departmental proceedings against all the appellants. When he went before the single judge upheld the discharge orders.
True.
Saying that you are not entitled to the protection of 311(2). Division bench says that all the appellants were entitled to the protection of
under
and
11(2),
the discharge orders are
and therefore if an inquiry was required,
yes,
they had to pass an order saying that no, we don't think an inquiry is required in this case, or we don't have it.
But what happened was, my lord,
possible to it.
There was an argument raised in the alternative that alternatively it is not practicable to hold the inquiry. That was an argument raised.
Now, can it be this way?
Yes.
Instead of whether the interim order is being complied with or not.
Yes, ma'am.
If the entire matter is taken up.
Yes, ma'am.
Subject to their filing of affidavit in opposition, and we find out whether your termination was correct or not. If it is wrong, you get benefits as entitled in law. If the termination is correct, chapter closed.
Yes.
Because if we try to find out what is the meaning of an interim order passed by this court.
Yes, madam. Meaning is clear, not be given effect to. It's another way of saying, no stay. In fact, the court had, Justice Saike had dictated stay. And my Dalit friends request, the senior government advocate,
be given
no
effect.
stay. Okay, not to be given effect to, means the same.
We'll come back at 2 if it is
Very well.
convenient.
Very
Huh?
well. I'm here.
Mr. Kohli will come back at 2.
Grateful.
Yes.
Wait, please, madam.
Hmm.
We were just on the judgment of the division bench.
Hmm.
And then, my lords, the interim order. If your lordships have the interim order. Before that, my lords, just have paragraph 140, my lords, because everything turns on this at page 293. My lords have.
Hmm.
Accordingly, the appeal is partly allowed by setting aside the impugned judgment and order of 18th March 2020 passed by so-and-so, resultantly, appellants are found entitled to the following reliefs. The discharge orders in respect of all the appellants hearing, which has been impugned in the connected writ petitions, are set aside. So, my lords, the discharge orders of 2018
Your
are set
discharge order was passed at a time when your initial period was over,
over.
but the extended period was not over.
There was no extension.
See, the court had taken into consideration all of that.
Yes. And court said,
And thereafter, the court divided you into three categories.
yes,
One, where it was already over, all
Yes.
the 4 years.
2 years. ma'am.
2 years, and by taking into consideration the maximum
I will
extendable
come to that. I'll
period.
come to that.
Just a minute,
Yes.
where they had completed the initial probation period of 2 years,
Yes.
and by taking into consideration the maximum extendable probation period,
Yes.
they are liable to be taken back into service.
Reinstate. Yes.
Second category formed was those who had taken into consideration the initial period of probation and the maximum extendable, but they had not completed that both.
Yes.
In that case, they were required to
Competent
pass
conduct
orders
as may be deemed fit.
as may be deemed fit. And
Appropriate
those who
considering
had
the
not
findings.
completed any period,
Sorry, my lords.
those who did not complete the initial period,
Yes. That's 7.
they would not
If
be
they-
entitled to reinstatement in service.
If there are any appellant whose probation period has not been completed,
Ah.
it is 2 years.
That is the initial 2 years.
Yes. So my learned friend, that discharge order with the,
It's not 2 years only.
my
Mhm.
learned friend's order
No,
of,
then Mr. Kohli, if we accept your submission, then 2 and 7.
I don't-
No,
If
Lordship.
there
was
just
no requirement of
respectfully-
7.
Sorry.
yes, no, my lords.
Respectfully, Lordship, the word initial is used in 2. Please come to 2.
Huh?
Initial 2 plus 2, right? And
Yes.
second, it's probation. So what is the total probation? Therefore, Lordship, respectfully, it has to be seen. Initial 2 plus extendable, and then it says, doesn't use the word initial in 7. It simply says probation. Probation is defined under the rules. Complete. The word probation comes in the rules clearly, divided into 2 parts. Initial period of 2 years, which is extendable. So therefore, you have to read it in context of the rules being probation.
Okay.
My lords.
Be that as it may. Tell us this. When are you filing your affidavits?
I have something to just for your consideration, and then we are in your hands. Only this, Lordship, now there are 4 things happening simultaneously. This is a big batch. And I just want Lordship to know, there were several senior counsels with set of batch of matters with them. One batch of matters, which was at that time argued by senior advocate Mr. Chaudhary, K.N. Chaudhary, they have gone and filed an appeal against the division bench's order, where the next date is the 23rd of July before the Supreme Court. Those list of matters are on my note at page number 4, para 6. Just for
Was
your
it this?
information.
Was it this same very judgment
Same
of the
judgment.
division
That's why,
bench,
Lord.
which is now pending before the Supreme Court?
Supreme Court. So there are about
Okay.
7, 8 of them, maybe 10. Appellants may be more.
Ah.
Second, Lordship, 2 separate reviews have been filed. One review is filed by the state specifically to para 67 and 68, saying that we have accepted the judgment, we have gone ahead and implemented the directions, but 67, 68 passes notes something related to the statutory rules which were not under challenge. So we have filed a review to the limited ground. Simultaneously, one batch of matters, which was argued by senior advocate Mr. D.K. Mishra, has filed a review which includes para 138, which my learned friend is also arguing on. So these 3 things are happening in parallel. The Supreme Court is next month, hopefully it will be heard then. The review, one review is coming up again next month. Third review, which is also including para 138, which is by some of the similarly placed people, no date is there. So I would only respectfully say,
We are
and then
we are having these few matters before us.
Yes,
and
yes.
there are 6 more matters of
We
the
have 1,
similarly
2,
placed
3,
people
4,
before another
5,
bench.
6, 7, 8, 9. 9 matters before us.
I am told 6 matters which are identically placed are before another bench.
Totally,
So on this
are
batch,
you aware of
I
it?
will request they are all heard together.
Wherever
So that
whatever my learned friend has filed, my lords, are before your lordships. But my lord, issue is this. It is not their case, my lords, that the state has gone up in appeal, taken a stay.
Is there a stay in any of the matters?
No. My lord,
No, Lordship.
Any of
his
the-
reviews are pending.
Supreme
And
Court is
Review.
stayed.
No,
Review
Supreme
are
Court
of,
has stayed, Lordship.
review are of-
Supreme Court has stayed.
Supreme Court has stated.
in
Hmm.
writ appeal number 141, and that was considered by a division bench of this court to say that this stay only is restricted to that, and the contempt, my lord, has proceeded. I just had that order, my lord, division bench judgment. The
So we are
author
not
of the
disputing
judgment,
that. We are not disputing it. It's factual.
Justice Kalyan Surana, my lord, he is the author of the judgment.
I don't have the judgment.
My friend just handed over, my lord.
This one,
Yes, just have paragraph 6, my lord. My learned friend's argument is recorded again. At
paragraph,
this stage, paragraph 6 of this order. At this stage, learned senior counsel for the respondent has submitted his submission to the effect that the order dated so-and-so copy has been produced in court today was the fresh discharge order in compliance of 141(7) of the judgment.
Hmm.
He has also produced a copy of the order dated 10/11/25, passed by the Supreme Court of India, by which the judgment and order passed in writ appeal number so has been stayed. The order is quoted below, my lord. Please, this is quoted below, my lord. And may us please see the Supreme Court only there were 47 writ appeals. Court says in writ appeal number 131 shall remain stayed. Now, my lords, accordingly, it is submitted that the judgment passed by this court is stayed. This contempt petition ought not to be proceeded with, and there cannot be any. Court goes
That
to
was
the
our
my lords, sees the memo of parties and says that it does not apply to this case.
okay, now we'll,
Just one sentence, Lordship, for assisting. My submission was qua the contempt not being taken up. I have placed the factual position before Lordship. So in that case, we had said, let
now
the contempt be heard later.
today,
In this batch, there are no appeals. My lord.
what is to be done?
But what I'm saying is this. my lord.
What do you expect?
Why it was listed from Friday to today was the concern that, my lords, the interim order of 28 August 2025 has not been implemented till date. That's something of concern, my lords. Otherwise, my lords, the writ of the court should run. Your lordships have said, my lord, that this order shall not be given effect to. Which means, my lords, my reinstatement is made out. The discharge order is quashed. The division bench has quashed the discharge orders of 2018. So today, my lords, I'm an employee. They have not allowed me to join. And my lord, they are our people, my lord. They are in extreme penury.
I have something to say after
Come
my
from
presentation.
middle class background. They should be allowed to join, my lord, subject to the outcome.
Two things. No, Lordship, I will respectfully
The writ
oppose
of the
that on
court
two
should run, my
grounds.
lord. That's my respectful submission.
So I have two specific arguments to oppose that interim relief being sought.
We are
Because
not,
for
we
my
are, we are
learned-
not on any, we are not passing any order of interim relief, sir. We will just
Then Lordship, it
evaluate
can
as
go for
of now.
final hearing. I'm so
We
grateful.
will only evaluate as of now whether the interim order has been complied with. If not,
So therefore, Lordship, my submission for
there are no
Lordship's
fresh interim
consideration.
orders to be passed.
Fair
Whether
enough.
there is
Lordship, my
compliance or not.
submission is, would Lordship for a minute come back to the order of 28, para 10,
28.
First
which is
order,
the
the interim.
Yes, Lordship. So therefore, on that, Lordship, it says, meanwhile, till the next returnable date,
Hmm.
so it's an ad interim, the impugned notification dated 21/7/25 shall not be given effect, as also consequent actions.
Hmm.
Consequent. Now, subsequent to that, my learned friend has amended the writ, and that notice was issued on 21st. So my argument would be that Lordship may consider us to
Amendment
file our
21.
affidavit in response, opposition, in which we will deal. And if you want us to file a separate one on the interim part, we will certainly do that. Because the second part to it would be that for my learned friend to take any benefit, it will be an adjudication on the point that he will have to establish that he falls within the second point, which is 141 Roman 2, to show that he completed 4 years before he can say that I can be reinstated.
Well, single judge have already held.
First, that
Interim order.
is by your note. The
No,
date
Lordship,
of
I'm relying
discharge
on the
was-
judgment. Please, Lordship may come back to para 141 2
There's already a view taken in this.
on
matter.
page 2. So Lordship may just note one thing. It's important to say.
If you are supposed to fall into this clause 2,
Yes.
you must have completed your initial probation period
plus
and
2
the
years.
maximum extendable probation.
It is extendable. So if they have extended it 2 + 2 4, well, then I have not completed 4. It's different. But those cases where they had completed 2 years, they were my lords, given a substantive post, a regular posting. There's a findings, my lords, of the division bench.
Lordship,
If I may show those findings, my lords.
and I will counter that at the end of it.
Paragraph 74, my lords. Please have para 74 at page 246, my lords. Because all this were
You have passed this order by taking them to be passed the order dated 21st of July 2025.
Less than
by
4 years.
start, Mr. Huh?
Less than 4 years. They have not completed
No,
4 years.
Just a minute. You have said that you have passed it in compliance of the directions at paragraph 141(2).
And 7.
Yes?
Yes.
And 7. Lordship may see that on
Where
page
is
68.
7? Where is
Page
7?
68 would Lordship come?
How can you have both,
Both.
is what we are trying to understand.
So may I assist Lordship? 2 parts. Lordship, I argued for him to claim relief under 141 Roman 2.
You have said that it would be read with 2.
Lordship, may just hear me. I'm
Your
just making
order
a
says
submission.
it is to be read with 2.
Of course, Lordship, because 2 says what? 2 says, Roman 2 says,
Those who have not completed 4 years.
yes. So my learned friend to say that I should be reinstated, whether in the interim or the final, has to show he completed 4 years. So he has to show that, number 1. Number 2, my learned friend has not challenged this direction. The direction is not challenged by him either in a review or in a petition with SLP before the Supreme Court.
Yes, sir. We are finding you are not there in that 4 years.
My submission is this. Your lordship saw, my lords, the findings of the division bench is that assuming I'm a probationer, my lord, what is my status? Either I'm a probationer or I'm a confirmed employee. Assuming I'm a probationer, court says that the benefit of Article 311(2) was available because the discharge orders were punitive and stigmatic. Right, my lord? Court found that there is no dispensation of inquiry under the proviso.
True.
So the finding of the court is that if
The said order was wrong.
yes, right, my lord. Now,
Once the finding comes that the said order was wrong,
yes, my lord.
the court divides you into 3 categories.
Yes, my lord.
The first category, as we understand, is those who had completed all probation. 2, 4,
No.
everything concluded.
The first category.
For those, they'll be reinstated. Yes?
May I respectfully submit, my lord. The first category was because the court says that the extension is not automatic. Extendable.
Understanding that the court says that there is an extendable period.
Yes.
Whether extended or not is a separate issue.
Yes.
There is an extendable period.
Yes.
So we will divide it into 3 categories.
Yes, my
The
lord.
first category, 2 years probation done, extendable also done.
Yes, sir.
You get a reinstatement.
Just
Second category is 2 years
done.
probation done, extendable period not done.
Then
Third category is
2 years not done.
not done.
7.
Now you are in
My
two.
lord, whether I am in 1 or 2.
Huh?
2 says what? That what will you do? My lord? Just permit me to read 2 again, my lord. For those appellants whose period of probation have not been completed by taking into consideration the initial probation period and the maximum extendable period, their respective service roles, the competent authorities are directed to pass such appropriate orders as may be deemed fit and appropriate, considering the findings rendered in the judgment and order, as well as by taking into account all the relevant factors that may be permissible in law. This be done within 50 days. So, my lord, what are the findings in the order? That the order is stigmatic, punitive, and I am entitled to the protection under 311. So, under 2, the inquiry under 311(2) has to be done before you dismiss me, discharge me. Now, my lord, what the state has done is turned everything in 141(7) and says, out you go. Well, the order has been completely nullified. Now, who falls in 2? Who falls in 1? Well, all the petitioners have been discharged, all the appellants.
Because all
Mr. Kohli, now we are taking a call.
Now, today, my lord,
Now
the
we
issue
are
of
taking
concern
a
is the
call.
order of interim order.
Show us
May-
from this. Please show us from this order dated. We'll go by your way. Mr. Chaudhary, take your seat.
Yes.
Mr. Kohli, just tell us. You have the government has referred to directions at para 141(2)
and 7.
and 7.
Yes, Lordship.
Now 141(2) required was applicable to those persons who had completed the probation, the initial probation, and maximum extendable probation. If both had not been satisfied, then 2 would apply. Yes? Now, if 2 would have applied,
Sorry, Lordship, I'm so sorry to interrupt. 2 will apply to such persons who have completed 2 years plus the extended period. That is what 2 says.
No. 2 say, then 1 goes. Are
No,
we
no,
reading
Lordship.
with the numberings differently?
I'm so sorry. Are you reading 141 Roman or 141?
Mr. Kohli, if we are not allowed to think correctly, I'm very sorry to say I may not be able to dictate a proper order.
No,
We have
Lordship,
been
I am so sorry.
discussing 140,
Yes,
Roman
Lordship.
1, Roman
Lord.
2, and Roman 7. We have
Yes,
not
Lordship.
been discussing paragraph 141 at any point of time. So
No,
let there be
Lordship.
no
No, no, no.
confusion
I
on
am
that.
sorry.
Please do
I'm
not
sorry.
interrupt. Listen to us. Mr.
Sorry,
Kohli,
Lordship.
I would so request you to listen to us.
Sorry, Lordship. I apologize.
140 Roman 1 says initial probation plus extendable taken together completed, reinstate. Yes?
Yes, Lordship.
Right. 142 says initial plus extendable not completed, then findings in the judgment and pass an appropriate order. Correct?
I have a different point, but I'm with Lordship for a moment.
We will
Lordship
just see
finishes.
that part of it.
So-
The competent authority are directed to pass appropriate order as may be deemed fit and appropriate,
Yes, Lordship.
considering the finding rendered in this judgment and order. Yes?
Yes, Lordship. Yes,
So
that-
whatever findings have been arrived at was to be taken into consideration for those people who had completed the 2 years initial part, but not completed the 4 years total. And at
Is what my
7, they
friend is-
say,
Yes, 7.
if there are any appellants whose probation period has not been completed, they would not become entitled to be reinstated in service.
Yes,
Now,
Lordship.
the court has tried to have the appellants in 3 categories. Or does it mean 2 categories? What do you say?
So
Let us have
may
that
I,
clarified.
Lordship?
1 or 2?
So may
No,
I-
just tell us that. What we are
No,
trying to
no.
understand. Are there 2 categories or are there 3?
Lordship, there is only one category with regard to relief. That is under the rules, the court has said you must complete your probation for you to be eligible for reinstatement. That probation under the rules is divided into an initial period and an extended period. The rules are at page 233. So therefore, Lordship, when we look at it, the argument of the state is that in this judgment, there are findings, which is correct, written in what Lordship just read, but there are final directions. The final directions, and most respectfully, Lordship, when I was saying 141, I'm referring to para 140, below 140, number 1, and then you have Roman 1, 2, and 7. Because para 141, not 141, but 140 bracket 1, clearly says that the relief is subject to. And it clearly says that that subject to is all the things down, which is Roman 1, 2, 3, 4, 5, 6, 7, 8. So therefore, when the relief is to be taken in terms of the discharge, original discharge, upheld by the single judge, when the learned DB it sets aside the single judge, it qualifies the relief in para 140 bracket 1 by saying it is subject to Roman 1, 2, 7, 8. Now comes the point of probation. The rules talk of probation as a comprehensive subject, as initial probation, extendable probation. 140 bracket 1, Roman 2, essentially is saying that you have to complete both 140, the 2 years and the extendable on the findings. The directions are based on the findings. They can't be read only one paragraph here or there. Ultimately, what will we implement as the state, Lordship? the directions. And 147, I mean 140 bracket 1, Roman 7 makes it clear that there will not be a reinstatement for those who have not completed probation, which is what the rules deal with. Probation divided into two parts. That is the state's argument, respectfully.
Okay.
And my learned friend has not challenged the judgment or sought a review of the directions. So we are bound by the directions. That's my argument. Would Lordship like to see the rule at page 233?
And by what time would you file your affidavits?
As much time as Lordship gives us. I mean, 3 or 4
Tell
weeks,
us.
whatever, Lordship.
By when?
Lordship, if gives us 3 weeks or 4 weeks, we'll do it, Lordship, and
No,
it can
let
be
us
heard
not,
finally.
let us not have this matter coming up without the affidavit again and again. On 21/5, they had filed the amended writ petition,
Lordship.
and 19/6 was the next order, and now we have. There also we were given, we had given time.
Lordship.
And now, tell us a date after the vacations to your convenience.
20th of or 21st or 31st of July, Lordship. Other matters are listed. I will physically be there.
When
but it's
was
subject to
it
Lordship's
listed?
convenience. The
When are they
other
listed?
matters,
Other
there
matters
are
different.
3 dates.
No,
20th of July.
how are the other matters connected here?
No, they are not connected. I will be physically
Right.
in Guwahati. That is the only thing.
Oh, you'll be physically.
But if
in
Lordship wants to
Guwahati.
keep it a separate day, then I'm bound by that.
No, we'll keep it separately because they have not been tagged till now. Although notice was taken.
So Lordship 22nd.
22nd of July. Okay. 22nd of July is what we'll have it. Yes, heard
If
Mr.
it suits
Chaudhary.
Lordship's convenience and my learned friend
Sorry?
doesn't object. If it
Sorry?
suits Lordship's convenience and calendar, this 22nd is good, Lordship.
22nd, yes, sir. Heard Mr. A. Chaudhary, learned senior counsel, assisted by Miss learned counsel for the petitioner, and also heard Mr. N. Kohli, learned senior counsel, assisted by the manager.
There is she's in court, Lordship, and my colleagues online are Mr. A. Roy and Miss N. Menon.
Okay. A. Roy and Menon Silobo, huh? Assisted by Mr. Dinath, learned senior counsel, senior government advocate, Assam, who prays for a week's time. Full stop. Mr. Kohli has submitted that the response to the writ petitions would be filed within a period of 3 weeks, and therefore he has prayed that the matters be taken up on the 22nd of July 2026. Full stop. Next paragraph. By the order dated 19/6/2026, this court had required the learned senior government advocate to specifically inform this court whether the interim order dated 28/2025 has been complied with, and if not, the reasons therefore. The order dated 28/2025 had directed at paragraph 10 that till the next returnable date, that is on 29, that is till 29/10/2025, comma, the impugned notification dated 21/7/2025 shall not be given effect to, as also all consequential actions thereto. Next paragraph. Mr. Chaudhary, the learned senior counsel for the petitioners, have submitted that by the order dated, what was the date of the
21st July 2025.
21st of July 2025,
5.
comma,
Page 68.
page?
68.
No. I'm not on that. Okay, we'll start from there. By the order dated 21st of July 2025, The respondents had withdrawn the government order discharging the petitioner passed earlier on 26 2018 and the governor of Assam in exercise of powers conferred under Rule 20 within bracket capital C of the Assam Service Rules 1998 had discharged the petitioner shown to be a probationer from service with effect from 26 2018, that is the date of discharge given by notification number capital A, capital A, capital P dot 380/2017/58, which notification stood substituted as directed by the court. Full stop. The learned senior counsel for the petitioner has submitted that by the orders passed in writ appeal number, what was the writ appeal number so far your client is concerned?
Well, my writ appeal is, it's
75 of 2020,
I'm getting it, 75.
comma. The court had directed as follows. Para 140 দিব, page 293, para 140, তাৰে 140 আকৌ এটা numerical 1 আছে, সেইটো দিব। মই টিক মাৰি দিছো বাৰু হা। 140, 1 দিব, 2 দিব, 3 দিব। Next আপুনি যাব 7ত, to page 295ত। আচ্ছা, number 3 যাব, 294 3 যাব। তাৰপিছতে 295ত 7 যাব। ঠিক আছে? By referring to the above, the learned senior counsel has submitted that the initial orders of termination issued upon the petitioner hearing had been set aside and this court had required the respondent authorities to pass appropriate orders as may be deemed fit and appropriate, comma, considering the finding rendered in the judgment and order, as well as by taking into account all the relevant factors as may be permissible in law. For those appellants whose period of probation had not been completed by taking into consideration the initial probation period and the maximum extendable probation period under the respective rules, comma, which for the petitioner were 2 years initially and 2 years extendable, full stop. The learned senior counsel has submitted that in the present case, there was no extension.
In so far as Pallavi Sharma is concerned, my lord, there was an extension which is under challenge. Because, my lord, there is no record anywhere. We asked, was this notification issued? They said it is not with us.
I'm not sure.
It was never served. So that's the amended prayer, my lords.
Date of extension of probation 27/11/2017. Acha, the learned senior counsel has submitted, what did I say, 2 years initially, 2 years initially, and would have been another period of 2 years as per the rules, extendable as per the rules, full stop. The learned senior counsel has submitted that although the respondents have asserted that there is an extension of the probation period given by the order dated 27/11/2017, the same is in dispute as the petitioners have not been supplied with a copy of the same. In any case, the learned senior counsel has submitted that since the impugned order of discharge had come after the initial probation period, which was till 11/8/2017, and before the extendable period that is 26/11/2019, bracket or likh, if the date of extension is taken to be 27/11/2017, the petitioner would fall in the category of 140 within bracket numerical 1 within bracket Roman 2, and therefore the petitioner, the termination of the petitioner having been set aside by this court, the petitioner would have to be, was required to have been reinstated in service, and it was only thereafter that the respondent authorities could have passed necessary orders, taking into consideration the finding rendered in the judgment
20th
dated
20th June 2025.
20 June 2025, as well as by taking into account all the relevant factors
Very good.
as may be permissible in law. The learned senior counsel has therefore submitted that with the order dated, when the order dated 28/2025 passed in this writ petition had stayed the operation of the order dated
21/7/2025.
21/7/2025, it was incumbent upon the respondent authorities to have initially to have immediately reinstated the petitioner to
Allow her
her
to join.
services.
Very good.
That is your submission in
Yes,
totality.
very good.
Replying to the same, the learned senior counsel, Mr. Kohli, appearing for the respondent authorities, has submitted that the order dated, what is the order of the appeal? Order dated
21st July 2025.
21st, no, this order of the appeal,
Order of the
appeal,
20th June 2025.
20 June 2025 had classified the appellants into two categories, one who had already completed their probation period, taking into account the initial probation period and the extendable period, and those who had not completed the aforesaid probation period of 4 years, full stop. The learned senior counsel has also submitted that the directions in para 140 within bracket 1 within bracket Roman 1 applied to those appellants who had completed the 4 years of probation, and it was only those of the appellants who were required to have been reinstated in service. The learned senior counsel has submitted that for those appellants who did not complete their probation period of 4 years in totality, the respondent authorities were only required to pass necessary orders by taking into consideration the findings rendered in the judgment and order, and by the specific direction by the specific direction given at paragraph 140 within bracket 1 within bracket Roman 7, comma, those appellants were not required to be reinstated in service. That is your argument, sir?
Right.
Have I
I'm
understood
grateful,
correctly? Yes.
Yes, Lordship.
The learned senior counsel has submitted that accordingly, the competent authorities in the government was required to pass appropriate orders withdrawing the discharge orders, which was done. Now, which was done and reflected in the first paragraph of the order dated 21st of July 2025, full stop, complying with the directions given at paragraph Roman 2, 140 within bracket numerical 1 within bracket numerical 2, comma, the respondent authorities had taken the decision to pass fresh orders substituting the earlier discharge orders. No, to pass fresh orders, comma, with a simpliciter order of discharge, comma, substituting the earlier orders, full stop. Accordingly, he submits that in compliance of the order of it was not necessary on the part of the respondent authorities to have directed the reinstatement of the petitioner in her service. Full stop. Yes, that is what you have said, sir.
Broadly, Lordship. And additionally, if it pleases Lordship, we are also saying that reinstatement would amount to the final relief at the interim stage.
He has further submitted that the reinstatement of the petitioners at this stage would require and would amount to giving the final relief prayed for in the orders, full stop. Prayed for in the writ petition, full stop. What is your relief prayed for in the writ petition, sir?
Well, the prayer in the writ petition, if your lordships come, page 62. Quash the notification, the 21st July 25.
Page 62. Worship. Acha, what happens on the quashing of it?
Quashing of 21st July order, my lords. Then we're restraining them from giving effect to that order. And C is reinstated.
The learned senior counsel for the petitioner has submitted that to cut off. The argument given by the learned senior counsel appearing for the respondents compliance of the interim order dated 28 August 2025 having been questioned by this court, comma, the submissions on the same has been heard. If the submission of the learned senior counsel for the state government is, for the respondent authorities, is to be accepted, comma, it would appear that that on passing of the interim order dated 20th of August 2025, comma, the respondents were not required to take any further steps to comply with the aforesaid order. Full stop. In other words, the suspension of the order dated 21/7/2025 by requiring it not to be given effect to would not result in any relief, any interim relief being granted to the petitioner in the writ petition. Full stop. It could not, no, the interim order dated 28/2025 required the notification dated 21/7/2025 to be not given effect to. On a reading of the directions passed by this court, comma, in writ appeal number, what did we say your writ appeal number was?
95 of 2020.
No, your writ appeal number was different, sir. Your writ appeal number was 75 of 2020, comma. And on a reading of the order dated 21st of July 2025, comma, it is noticed that the order dated 21st of July 2025 does not reflect that the findings of the findings rendered in the judgment passed in the writ appeal and order insofar as they relate to the present petitioner had been taken into consideration. Full stop. The order quotes that the petitioner was not found fit for confirmation as on 21st of July 2025, and the orders were passed in exercise of powers conferred under Rule 20C of the Assam Civil Service Rules to discharge the petitioner with effect from 20/06/2018. Full stop. It is another matter, the termination of service. Leave that out. On a consideration of the materials available on record, comma, I am of the considered opinion that the respondent authorities on the comma, on the impugned notification dated 21/7/2025 being kept in abeyance, comma, were required to have taken further steps for compliance of the same, comma, since the order dated on the orders passed in the writ appeal had directed that only those appellants whose probation period had not yet been completed, whose probation period had not been completed, would not be entitled to be reinstated in service. Full stop. Next paragraph. in the, it has been also brought to the notice of the court that there is, that some of the appellants whose case was taken up together with the case of the present writ petitioner in the writ appeal had approached the Supreme Court by preferring SLP number 29588 of 2025, by which and the apex court in the while considering the aforesaid case had stayed the operation of the order dated 26/2025 passed in writ appeal number 131 of 2020. It is not the case of the respondent authorities that the aforesaid SLP either is with regard to the orders passed in connection with any appeal. It is not the case of the respondent authorities that the said order would also govern the case of the present petitioner. It has also been submitted by the learned senior counsel appearing for the state respondents that there are other matters arising out of the same writ appeal but from different orders passed by the respondent authorities with regard to different appellants whose matters were heard together, but the same are not before this court today, full stop. The learned senior counsel for the respondent has prayed for some time to file their affidavit in opposition as already noted in the first paragraphs of this order, full stop. List these matters again on the 22nd of July 2026, full stop. It is made clear that since there was already an order directing the respondent authorities, there was already an order by which the notification dated 21/7/2025 was required not to be given effect to comma on the success of the writ petition at, in the event that the writ petition succeeds, comma, the same will be at the risk of the same shall list the matter again on the 22nd of July. The affidavit filed, the affidavit filed by the respondent authorities would also explain and I would also contain the explanation called for by the order dated 19/6/2026, since this court is of the prima facie view that the effect of the order dated of the interim relief granted to the petitioner by the order dated
28 August
2025 has not been effectively complied with by the respondent authorities, full stop. It is made clear that this is only a prima facie view at this stage, and the same will be considered upon filing of the affidavits by the respondent authorities. List again on 22nd of July. Let us see, since there is a difference in the understanding of what 1, 2, and 7 would mean, it is only on their affidavit we can come to a finding as to what would be the meaning there.
Very well.
Is it not?
Yes, yes.
If we now say reinstate, then we are giving you the final relief. And
But orders should be given effect.
No, the
interim order.
writ appeal, the
Lordship
writ
has
appeal
asked
had
for an
already,
interim-
the writ appeal had already recorded that you are not there in service. Now, when they are passing another order against you, which is under challenge,
And
this
substituting
can
the-
this can be rectified. Whatever you're suffering now can be rectified in the final orders. So we are not granting you the relief
Very
for
well.
reinstatement today. But when they explain it in the affidavit, perhaps we can all argue other matter. And we will come to a more definitive finding.
Very well.
Yes.
Well, the interim order to
For
continue.
that. I'm
The
sorry,
interim
Lordship.
order, interim order continues. Yes, sir.
I'm so sorry, Lordship. On VC, I was talking over you.
There
It
is
was
no difficulty, sir. There is no, we are encouraging people to do that.
My lords,
Grateful, Lordship.
the other matters, my lords,
Huh.
I have a chart, my lords, where the writ appeal numbers will vary.
Yes. And there are similar orders in all those.
Yes.
Or one order is governing.
July 2025 discharge order
No. What I'm asking is the
And-
order which was given here.
for extension.
No, that explanation being called for, is that
Yes.
order there?
Yes,
in
yes, all interim
everyone?
orders are there, similar.
Now, interim orders are there, but there the explanation has not been called for, yes?
No.
So
Well,
what
no,
we'll
but
do
your
is-
lordship said in this order, last order, list the matter along with all these writ petitions.
Huh.
Because it was brought to the notice.
Give us the chart. Yes, give us the chart. Yeah, to interim orders passed earlier will continue.
Well, there are 23 and 20, item 23 and 26 I have marked in red, my lord.
Huh?
These are the two petitioners where there are extension of 2 years. 2
Okay.
plus 2. Rest, there are no extensions, only 2.
No, that we will take up when the affidavits are filed and
In fact,
we
the
take up-
affidavit will have to be filed in all these matters also. They're all connected.
perhaps consideration of each of the petitioner individually
Really.
and what orders are required to be passed in
Your lordship can
against
list
each
along
one of
with-
them.
List along with this matter.
List along with the WPC
Great.
number এসোপা দি দিব এই তলত যিটো আগৰ order যিকেইটা নম্বৰ আছিলে list along with WPC number so and so আৰু interim orders চাই ল'ব প্ৰত্যেকখনতে খুলি য'ত interim orders আছিলে as it is interim orders to
The
continue.
last column, my lord, has the date of the interim orders. All interim orders.
এইখন লৈ পেলাই তেতিয়া এইখিনি লৈ পেলাই মূলত বহি দিব. Yes, sir. Anything further, Mr. Kohli?
No, nothing. What I'll do, Lordship, on that day, we'll just make a small little compilation in terms of, the differences in each one of the writ petitions, if any. Instead of going through
In
files,
that-
we'll
in-
make
in-
one as a read.
Then in each of the cases, perhaps you'll be required to file separate affidavits.
We will do
Yeah,
that.
So that we can decide
That
each
we
of the matters if decided individually and if individual orders are passed, whether to reinstate or to simply pass orders, it will be much easier for us to.
We will file in all of them responses. We will take one as a lead for the overarching and then deal with the individuals. That's what I was saying. We'll bring a chart.
That would be better because if we try to group up, same thing will be repeated again and again.
Yes, Lordship. I'm grateful.
Thank you.
Very grateful.
Thank you, Lordship. Grateful.
List along with WPC number, Iman. Mr. Chaudhary, item number 8 will also go along with them only.
Yes.
Item number 8 to list along with so and so interim orders accessory to continue. Ase niki kintu protection side level.
Ase, the interim orders is
Just this is between us just to check for once.
very grateful.
One and two. One lordship, I got the instruction. Very lordship, the original sanction, which was a sanction order which was passed by the SP lordship. Now it was a rectified lordship.
Sanction of what?
Regarding the.
What is the sanction? What sanction are we talking of?
That was rectified. Now the matter may be infructuous.
Huh?
Item 1, lordship. They challenged the sanction order which was passed by the SP Karbi Anglong.
Okay.
According to them, lordship, SP Karbi Anglong is not the appropriate person that to pass the order.
Has it been withdrawn?
Lordship.
Item 1 is WPC number, sir?
Yes.
1487.
Yes, lordship. 148. It was not withdrawn.
The earlier sanction order has been modified.
Yes, lordship. Modified. Now the sanction order was passed by the appropriate authority.
Above represented the validity of the legal order granting proceedings sanction by so-and-so. For value of the past and interim order staying the operation of the prosecution sanction order with Iman with the liberty of the respondents to pass any other appropriate right order dated Iman the appropriate of the granted fresh sanction to prosecute in connection with Dhula PS. However, since the above petition is still pending in the Honorable. None appears for the petitioner. Very good. None appears for the petitioner on call. None had appeared on 562026. Full stop. By the order dated 28/2/2020. Assisting counsel. এইটো হেৰি কৰকচোন এইকেইজন উকিলক এই পেটিশনৰ উকিল কেইজনক এটা ৰানটা দি দিয়ক স্ক্ৰলটা দি দিয়ক হা আৰু যদি কাৰোবাৰ ফোন নম্বৰ আছে ইম্পিটাৰ মাতি দিয়ক Mr. Goswami, we are running a scroll for the counsel for the petitioners. We'll wait till 3:15. None appears, we'll pass orders. What we have noticed is senior counsel had appeared in the matter. Senior counsel personal knowledge is not keeping well nowadays. Others' name we do not know whether reflected or not. Although reflected, what we'll do is we'll run a call, nobody comes, we'll do it. Yes, madam. Any scope to dispose this off? He has, we had noted down in the order dated 19/5/2026. What do you say on that?
The Lordship wanted me to address this. First point was the Lordship pointed out that presenting of
One was appointed, but he had recused. Thereafter, there is no order.
that is record also reveals that. So I was just going through some of these judgments and whether it will per se initiate the proceeding.
Not per se. He has to show how he was prejudiced. Now, in the absence of a presenting officer, who called for the witnesses, who displayed the documents?
But my lord, here there is no allegation of bias against the inquiry officer.
Need not be in the very absence. If suppose it is a tax document that you have filed the wrong tax, or a property has not been declared as is required to be declared, and therefore the DP takes place. A simple printout of that document, enough. But when you are going for a allegation of a misconduct, in the absence of a presenting officer, who does it?
My lord, number one, my submission is that there is no allegation of bias. There is no allegation that he presented himself as a prosecutor in this case. There is no such allegation by the petitioner. He simply says that this was not sent for his handwritings, were not sent for forensic examination, number one, which we also had admitted in our inquiry report that this was not sent for the forensic experts. And my lord, if I may submit, it was not sent for a specific purpose for his benefit only. Because we just wanted to impose minor punishment. Had it been sent for a forensic expert, there's been some major punishment. And
May I know why?
because my lord, there was
Because now see, now the biasness comes out. The moment you are thinking of punishing by with a minor punishment, that he will be punished is already determined.
He admitted, my lord, initially,
Hmm.
can you see the first answer given by him of the charges. First, he said, I apologize.
Hmm.
First, he said that there may be some mistake on my part. He also had admitted that.
Mistake and misconduct is not the same.
Yes. He said that I knew that the originals were not there. I was not interested by any written order by the superior officer. Even then, and then he goes on fortifying his case on letter part. He says thereafter that it was not sent for forensic first report. And now, my lord, who are those, my lord, who are examined in this case? Four people who have been examined.
Hmm.
Now, my lord,
Who called for them?
in this case, obviously in the absence of the
Presenting officer.
Hmm?
Presenting officer.
presenting
So
officer.
the inquiry officer had to choose the witnesses he want to be produced.
It was given to him at the beginning only, and he also wanted to go through all the documents against him.
Where is
which
that
were
first
taken-
charge sheet? Where is the charge sheet? Okay, we'll go through it again. Show cause notice. Where is it?
Page 43.
Hmm? Hmm. Six witnesses. How many were examined?
Four very.
Twelfth of February, 16th of May, 4th of June. Hmm. Ah, yes. Now, if the presenting officer was not necessary, why the initial
I
appointment?
don't say, man, it's not necessary. I'm saying that it is not.
There is no allegation that he was prejudiced. And the other part,
Why there is a procedural lapse.
Huh.
One person, Achintya Roy, he was examined on 16/9. After examination, after recording the statement of the petition.
Hmm.
So in this regard, my lord had gone through some judgments which said that strict rules of evidence will not be applicable in this instance until and unless a case of petition has been made out by the delinquent officer.
who suggested that extra witness and why?
He was there on the list. Perhaps it was later on it was realized that he may also give his statements.
And what about the cross-examination part?
Cross-examination, he never prayed for it. That
Not necessary to pray. It has to be either denied or refused. He refuses to cross-examine one sentence.
there's nothing on record also that he wanted and he refused
No,
something.
he does not have to want to. It has to be recorded in some, it has to be recorded in that particular document itself or in an order saying that he refused cross-examination.
This is the regarding cross, whether he asked for cross-examination and specific time. Even otherwise, my lord, if I may submit now at this stage, if this reopens,
Mhm.
it will be detrimental to his interest.
He is here to stand for it.
What
He is
they
here praying for it. Is it not? Now, when he says, I was not allowed to cross-examine, at page 89, he says, I was not allowed to. So it has to come from the respondents by some document that no, it was he who refused.
I have checked up, my lord, there is nothing that he asked for and he was not allowed.
Page 87, if you know.
And where did you take the ground of the absence of a presenting officer? In your appeal or even in the writ petition?
Lordship, regarding Lordship, absence of inquiry of his presenting officer came to light when the document was shown to us as per permission of the Honorable Court. Could you-
No, during the inquiry, the petitioner would have known whether there
Because
is a
the
presenting
inquiry
officer or
was
not.
conducted behind the back. Petitioner was not informed regarding date. That is all Lordship we have pointed out. Date of inquiry, when witness was examined. nothing was-
When was the, where are the orders which were supplied to him that the inquiry will be held on so and so date?
No, that is
No,
not there.
no.
These are not there.
Unless he's informed of the dates.
Not strictly as per.
So we will not go into the other part of it. What we will say is that he had not been informed about the conduct of the proceedings by the inquiry officer. And since there was a total absence of any opportunity to him, the inquiry proceedings have to go. Now the other relief, whether to allow the a fresh inquiry to take place on the same
That
charges.
liberty may be given to him.
Sorry?
Liberty may be given to them. If they
The
want.
liberty would be with them. So should we say in the order that on going through the records, it is your fair submission that notices regarding the proceedings in the inquiry had not been sent to the,
Regarding my lord,
if it is a matter of
recording
record,
Statement.
recording of statement was not, he was not intimated. Can we take it down as your statement based on records? We can do that?
I have prepared a small note here,
That will be helpful. Yes, kindly show us.
like get more judgments here.
We are not, we are not going into the rest of it. We will not go into the presenting officer part of it. We will not go into the absence of a cross-examination opportunity, nothing. We will only say that having heard for a considerable length on the earlier occasions, today, on going through the records, specific query as to why there was no opportunity of cross-examination, going through the records, you have fairly submitted that the record regarding intimation of the dates of inquiry or dates of the proceedings by the inquiry officer are not available, which I will infer is an indication that he was not informed about the proceedings before the inquiry officer. Therefore, the inquiry report, consequential termination and appellate order goes, and what penalty were you imposed with?
Withholding of two increments.
The withholding
major
of
punishment.
the withholding of 2 increments will be kept in abeyance for a period of 3 months.
Not 3 months, Lordship set aside, they will, if they, liberty will be given to make a fresh inquiry if they check.
That is what happens, sir. When you do not let the court finish what it is saying. It will be kept in abeyance for a period of 3 years. What we had suggested was kept in abeyance for a period of 3 months, during which time they would be at liberty to conclude the inquiry proceedings in a manner known in law, failing which the penalty would go. Now you are not, you interrupted us, so we will simply give them the liberty. Yes? Hello, disposed. Disposed. Huh? 22, no? Good brand. I dispose the query. Pass orders. You'll pass orders. Disposed. You can give me your note.
We can provide the list of dates also.
List of dates or notes. Huh?
We have given the list of dates on this.
We will just refer to the observations we had made in the earlier order, and we will say that in today's hearing this has come up, therefore not necessary to proceed to the other part.
All these are judgments regarding.
Judgment, no, we have not produced.
We will not make it a big bunch. We'll as small as possible. Yes, then next. Is there anybody appearing in this matter?
Well, it's no,
No.
no. Well, it's there are two briefs. One was with Mr.
No,
Kumaria.
what has happened is this: in the first writ petition, the challenge was with regard to the sanction of prosecution granted. Today, he has produced a document which says that your challenge was to the authority who had passed the sanction order. The DIG, who has done it now?
DGP.
The DGP has done it.
Well.
No authority higher than him. So we are closing the first writ petition, saying that it has now become infructuous.
Yes.
In view of this order, number one, in the absence of the petitioner, we do not have an option but to close the writ petition. Interim order passed earlier, if any, stands vacated.
Client has taken back our brief. my lord.
So here it is also here. There is also a note saying that the trial is not proceeding because of the interim orders passed in the year 2020. Now that there is a fresh sanction order,
Yes.
let him question that if he wants to. This has to go.
Yeah. In fact, Mr. Goswami also has changed sides. PN Goswami.
No, not so far. This case is related.
No, because before going to that side, he
No,
was
no.
this side.
For
He
this-
was for the,
for-
now he's for the state.
For this particular case, he'll recuse himself, but he has not changed sides so far as this case is recorded.
No, no.
None appears for the petitioner on call. Full stop. What about the second case?
Second case, Lordship.
We have returned the file, my lord.
Okay. Okay. You are at liberty. None appears for the petitioner on call. None appeared on 562026. Full stop. The learned, Mr. Goswami, the learned, you are additional senior government advocate.
Yes.
Additional senior government advocate has placed before this court an order dated 29/5/2025, comma, which contains a reference to an order dated 8/1/2024 passed by the Director General of Police, Assam, Gauhati, granting sanction, granting to Katidiba, according sanction to prosecute the present writ petitioner in connection with Dhula PS case number 18 of 2018. Full stop. The petitioner in this present writ petition had challenged the order dated 31/8/2019 passed by the Superintendent of Police Karbi Anglong, granting sanction against the petitioner for taking cognizance of the offence by the competent court in connection with Dhula PS case number 18 of 2018. An interim order had been passed on 28/2/2020, restraining the respondent authorities. No, keeping in abeyance the order dated 31/8/2019. Full stop. The learned additional senior government advocate, Mr. Goswami, has submitted that with the passing of the order dated 8/1/2024, comma, the present writ petition has become infructuous. Full stop. In the absence of any representation from the petitioner, comma, we do not find any ground to infer otherwise. Full stop. Accordingly, this writ petition is closed as infructuous. Full stop. The learned additional senior government advocate shall provide copies of the letter dated 29/5/2025 and the sanction order dated 8/1/2024 for being retained in the records of this case. Copies as and when copies furnished by the learned additional senior government advocate are retained in the record.
Secondary
Next to be
secondary promotion.
writ petition accordingly disposed of. Yes.
secondary promotion.
It also, the item 2 is also come in first source.
Why?
Lordship, that was challenged against against.
Departmental proceeding.
No, Lordship, departmental proceeding already gone. It was withdrawn, Lordship.
Huh?
That was not.
Okay.
Now this petition, this petition for send him to the training for promotional training, Lordship. That is their prayer, and accordingly, your Lordship, on 16/7/2021, this honorable court directed the respondent that to send him to the training, Lordship. But confirmation is not given. Therefore, now both the criminal case and the department proceeding are in force, Lordship, are in proceed, Lordship. And therefore, this promotion, Lordship, will not.
It is not about promotion, it is about confirmation.
The confirmation regarding the promotional post.
Eh?
Yes, Lordship, that is Lordship, kindly see, Lordship, yes, right. SIUB, there is no provision for promotional promotion to the rank of the inspector, UB of the police police in Assam Police Manual. Moreover, the petitioner, SIUB Ranjit Hazarika has not confirmed the rank confirmation, Lordship.
Rank in the rank
Yes.
of sub-inspector.
Yes.
Huh.
Of the police become he has a departmental proceeding by DP number so and so.
Because there is a department proceeding,
Yes,
you cannot confirm the
yes,
post.
yes,
Confirm
yes.
in the rank.
Now, Lordship, they challenge that the departmental proceeding was stay at the time of filing this writ petition,
Mhm.
and also the criminal case was also stayed
Huh.
at that time.
Huh.
Now, in this after disposal of the writ petition number 1, Lordship,
Huh.
here in this
The criminal case is gone.
gone,
What happens to the departmental
Lordship.
proceeding?
That was withdrawn.
The writ petition was withdrawn.
Yes, Lordship.
Where do we find the reference to all that? Why are there so many writ petitions?
Lordship, number 1, Lordship, challenge the sanction order.
No,
passed by
no.
the SP,
Are we on the
PS1.
same? WPC 32?
It's
3279.
Yes, 327.
Just a minute. This WPC is shown to be with so many other writ petitions. Why?
The WPC 2150/2020 it
Hmm.
was withdrawn on dated 16/10/2025.
Just a minute. See,
1487. Writ petition number
okay, we'll
1487.
give you some time. Just tell us what has happened to all these.
Yes.
It would be too. How many writ petitions are there?
Now 3, Lordship. Yeah.
Give it to me. What has happened to all these? We'll call it after some time. You go through it. কিমান হৈ গ'ল 8ৰ পৰা কিমানলৈকে হৈ গ'ল 8ৰ পৰা 8ৰ পিছত আকৌ 21ৰ পৰা 32লৈকে হৈ গ'ল ন কি হৈছে এতিয়া আমি ক'ত আছো 3 হৈ গ'ল ডিসপোজ অফ হৈ গ'ল ন এতিয়া আমি 4 নহয় এতিয়া আমি 1 2 চাই আছো You, Mr. Goswami, will take that up. Do you have the information for all the? In one of the orders at the top, you will find around 10 of the 10 writ petitions.
No, sir, I have only 3.
What happened to those? Why were they tagged together? Find out tomorrow. Find out. Kindly find
Yes,
it.
I will find
Next tomorrow. You take it out after some time if you can find out.
Item 4.
Hmm.
It's sold at secondary department.
Ah.
Elementary.
So I guess
It has been submitted that the cause list reflects the counsel for the respondents as standing counsel, secondary education, whereas it was the, no, whereas the standing counsel, no, whereas it is required to be reflected as the standing counsel elementary education, full stop. Register to make the necessary corrections and list the matter again when you have not filed your affidavit, sir.
Lordship, in this matter, actually, notice was issued on 2nd of May 25, Lordship. More than
True.
1 year is over. They have not.
2nd of May 2025.
2025, Lordship.
And then you went for a mediation on 9/9/2025.
No, I did propose for mediation. It was.
Whosoever
automatically
did it went for mediation.
We did not agree, Lordship.
No one agreed.
No one agreed, Lordship.
Oh, we saw that order. We thought you had agreed. Not agreed. What do you want in this repetition? What are you praying for?
Pay fixation, Lordship, stepping up.
List
the
this
pay-
matter again on the 29th of July 2026, full stop. It has been submitted by the learned counsel for the petitioner that notices were issued in the matter in the month of May 2025 and no response has been filed by the respondent department as of today, full stop. Respondent, respondents are put to notice that in the absence of an affidavit on the next date of listing, comma, the matter may be taken up for disposal on the basis of materials available on record. সেইটো কলো নেকি ওপৰত কলো নহয় যে shall reflect as so and so, should be reflected as so and so, registered with the corrections.
And it is in fact a second round of litigation. Second round of litigation.
Second
round of litigation otherwise. It's fine.
Hopefully the last.
July. Oblige.
Hopefully the last. Yes.
This matter is related to non-receipt of the family pension as per the scheme of the government petitioner husband.
Husband of the petitioner, name of the husband of the petitioner.
Husband died in harness.
Before a bench without me. Sivsagar Dhemaji. Not looking for where? Huh? Bijoy Somua. Lokhimpur, Lokwakham. Not by me, sir. I'll tell you why. I had made a chart. All the details were there. I should not be picking up these matters. Because each file I had the occasion to list before a bench without. Yes?
Lordship wanted to peruse the order dated 3/6/2026, Lordship.
3/6.
3/6/2026, Lordship. That has been provided by the court master.
This is what? So this is some other repetition.
Lordship, as per this order, Lordship passed in this writ petition, Lordship. This particular matter was also to be listed on 15/7, Lordship.
This one?
Lordship. The current writ petition, Lordship.
Okay.
The order passed in
The learned counsel for the petitioner has submitted that as per order dated
Lordship 3/6/2026, passed in a similar
3/6/2026.
Lordship.
Passed in WPC number 4426 of 2025. Both these writ petitions. Now, both the writ petitions were required to be listed again on 15/7/2026.
Lordship.
Huh?
Lordship. Along with another writ petition, Lordship.
Along with WPC number
Lordship.
4420.
Lordship. 4420 of 2025.
4420 of 2025. Huh? Registry to verify and list accordingly.
Lordship.
Respondents at liberty to file their response in the meantime.
Where is the lordship? Lordship, we have sent the application authorization for pending. Last week. Regarding commercialization of.
Yes, sir. The affidavit will help you.
Look, it's a covered case also. Affidavit is
But
not
without the
required at all.
without the affidavit, can we agree to the covered?
Let them file affidavit on the inception, date of inception of the writ petition. They are taking time. Each and every day they are seeking time. No effective submission, nothing else, my lord.
Heard Mr. D.N. Bhattacharya, learned counsel appearing for the petitioner. You are Mr. D.N. Bhattacharya?
Yes, my
Heard Mr. D.N. Bhattacharya, learned counsel appearing for the petitioner. Also heard the learned standing counsel, Secondary Education Department, who has prayed for being granted 2 weeks time to file the affidavit in oppositions, comma, stating that the same has been prepared and is under vetting, full stop.
Let it be last chance, my lord.
Accordingly, list this matter again on the 24th of July,
My lord.
24th of July,
My lord.
full stop, by comma, by which time the respondent shall ensure that the response is brought on record, full stop. An attempt would be made to dispose of the writ petition on the next date of listing, comma,
Very
even
simple
in the
question, my lord, whether you guys is required or not. It is
even in
already
the
decided.
absence of response from the respondent authorities, full stop.
Obliged.
31 and 32.
Also, with the abandoned question, I have also filed a review application along with this petition. And already, Lordship, I have granted a leave by this honorable court on last occasion. And Lordship,
I forget why you were required to. Oh, yes.
because same selection has been challenged by this honorable court and that has been upheld by this honorable court by judgment dated 4/4/2023.
It's something different.
Same selection process.
Order, first, text of the first case is different, second case is also different.
But the selection has been upheld.
No, so far as the general counsel concerned, he is OBC candidate.
Okay.
There is no reservation for OBC in the selection process.
Yes.
In the advertisement.
Address us, sir. Don't address him. Address us. Don't address him. Address us. We'll understand quicker, hopefully. Huh? Yes. What was your case? Which one do you want to take up first?
Lordship, first case 5364.
Huh?
WPC 5364.
Then this review petition, has it come together?
Lordship, subsequently.
No, is the review petition here?
Lordship.
Review the orders. Why do you want a review?
Because it was pointed out that I should file a review application because this order was passed subsequently and that was not placed before the earlier order was not placed before this honorable court when second order was passed.
First, there was an order upholding. Then there was an order holding that it is not good. Then you file a petition. And now you have filed a review in this earlier round of.
We have applied for the post for selection post.
There was a order of this court upholding the selection
process.
Then there was another order which said that selection is not good.
No. Another order remanding the matter to the authority to decide.
To decide. Okay. Now, once it is sent back to decide, you have now filed another writ petition.
No,
Since it was sent back.
We are not the petitioner in the earlier petition also.
Okay, then they have to be here before that. Before we can take up your review or the other writ petition.
Because
it is the order in the review. Only if the earlier order sending it back is set aside or modified, it is then your writ petition would have legs to stand on. Yes? So for that to happen.
Without that also, Lordship, because Lordship will find initial order at page 30. I am not a party to the writ petition also.
Could be.
I am a selected candidate.
Then you must file a writ petition against the orders passed in the writ petition.
That is filed.
That you have not done.
As a abandoned question, I have filed.
So let us issue notice on the review petition today.
So already appeared also. Private who has filed this petition, who has appeared, his name has been shown in the cause list.
Yes, who appears for the private respondent?
No notice has been issued.
Yeah.
The notice has not been issued.
This is item number?
Item number 31 and 32. 32 is the
31 and 32.
review petition. 102.
Hmm.
When the leave was granted, the council representing the petition was appeared. The leave application, Lordship will find.
No, name is not shown. In the cause list, name is not shown, sir. Should we go against it?
Lordship will list this matter any other date showing the name of the private respondent.
List this matters. We'll have it immediately after the vacation.
Before vacation also if possible. Because Lordship has already heard the matter.
Who was appearing? US Bora. Who is US Bora? Huh? You have filed the review petition. You have given the name of Mr. US Bora advocate.
No, I have.
How do
given
you say
copy
you
to
don't
him. I
know?
have given copy to him, and accordingly, leave petition was listed before his honorable court. And when leave petition was heard, he was present, and he has said no.
So
No, no, that's not the case. Who has appeared?
The
Nobody was
council,
appeared.
council representing.
No one has appeared. I was
leave
appeared
petition
in the
concern.
I was filed.
Leave con review con no hai. Leave to review.
That's it, 177 of 2026. When I'm making a submission before his honorable court, Lordship.
177
there is
number
not
থকা কি আছে?
this.
কিবা আছে? এখনকে দিয়ক। Okay.
177 of 2026. Lordship can see the order.
I'm sorry, the order 562026
Leave
is when your leave was granted on by the order dated 562026.
Lordship.
It does not record any counsel for the opposite parties. You can have a look.
But my submission is, Lordship, I'm making a submission on before this court that he was present before this court. Advocate for the.
You see, sir, our trust on you. Our trust on you.
I will
If not reflected by the records, it
Okay.
will become difficult. So we'll issue notice on the review petition. We'll have it immediately after the vacation. Inform him if he arrives on the next date, matter is over. Yes?
Showing the name of the review.
I will not do that. I will ask you to inform him of the next date. Let him be here.
Lordship.
Unless he files a wakalatnama, can I reflect his name? Cannot. There has to be a wakalatnama here for his name to be reflected. But Mr. S.K. Goswami Learned Counsel, it will review petition khonot dibo, ha? Review petition number kiman? Huh? A review petition put here say number nine. ঢিলা পাইছে মাতক এতিয়া মাতক কিয় নাম্বাৰ নাই তো লগে লগে চেক লওক ময়ো দেখো Heard Mr. S.K. Goswami, Learned Counsel, appearing for the petitioner. It review petition number to review petition. Also heard Mr. T.C. Sutia, Learned additional senior government advocate, assisted by.
No, he's the application for review.
Huh? And he's for the respondent number 4 and 5. Huh? No, review petition. Do you have a copy? You are appearing for the Deputy Commissioner, Chairman Selection Committee, and the District Commissioner, District Nalbari? Yes. What about the Selection Committee, District Commissioner Nalbari? Then yes, for 3, 4, and 5. You are appearing for?
Yes, 3, 4.
Mr. Dotto for?
1, 2.
1 and 2.
In review.
In review petition for stuff. Issue notice on the respondent number 6 by registered AD. Full stop. He's okay. By registered by registered in by speed post as well as by ordinary process. Full stop. List the matter again on.
Immediately after vacation.
We'll have it on 24th of July. 24th of July 2026. That over review petition order. Huh? Next to WPC 5364 of 2025. Huh? List along with review petition number. On 24th of July 2026.
And Lordship can also see the video in the website. It is available. The council representative appeal. I will download it.
Some formalities are required which has to be on record.
Understand, because the record did not reflect. Record does my order leave appeal order is not reflected. But indeed, I will download the Lordship from the website. Council representing the petitioner was present.
We trust Mr. Goswami enough not to be given visual proof. Advocate লিখে নিয়ে পঠিয়েছি তেলে নাম্বার না এইটোতো লিখি তাহলে নিলিখিব নেকি বাৰকোডটো যেতিয়া স্কেন কৰে ইয়াত আছে নাই নে দেখ লিখাই দিয়ক এতিয়া লিখাই দিয়ক নেক্সট কোন
Oh, those, I think 11. In this case, we are asked to take Dosti service. We have also filed affidavit with the report of the, enclosing the report of the Dosti service.
Huh.
So,
Whom did you serve your dusty notice on?
so service may be treated as a completed, my lord.
Who's on whom? On whom?
My lord, respondent number 4 and 5.
Sir, will I look into who is respondent 4 and 5? Tell us the party name. Private
yes, my lord.
party, NIOS, DLA, whom? Who represents 2?
My lord, respondent number 4 principal, Harendra Sittar, senior secretary. 5 is Deepak Uja, proprietor of net.com, BK Road, Panchali.
DJ H. Gupta. H. Gupta, CGC, DJ Gataran. Huh?
6, 7, 8, 9.
We'll take it up after some time. Let Mr. Gupta be here because he has paid for correction in his
My lord,
DLH certificate.
Yes.
Neither can you do it, nor can any other person do it. It has to be done by Mr. Gupta.
my lord,
Look for him, get him.
my lord.
10, 12, 13.
May be lordship.
Yes, sir.
My lords, on the last occasion,
Hmm.
by an order of
He also personally appeared before my.
Huh?
He also personally appeared before my.
Okay. Did we ask for his appearance?
my lord, this pertains to that particular my lord, salaries which were not disbursed to the petitioner. and
Yes,
despite
sir.
his
Why did you
lordship's
make
order-
that? Why did you make that submission? It will not lapse. What happened to it?
On 6, on 30th March,
Huh?
I informed that it will not lapse in the current financial year, as it was in the account. So, and the fund was still here, 26th of May. And in the next paragraph, I also informed that we wrote to the finance department and saw the instruction what to do with the fund. And I informed that whatever. the-
So now when on your assurance, the court had done something. Before returning the money, did you tell the court that, sir, my assurance they are not listening to, I have to give back the money now? You did not think it fit. From where will you now get this money? From where will you bring this money now?
It is in the government, treasury only.
You said it will not go back to the government. That was the entire apprehension. The entire writ petition, the interim orders were prayed for or whatever was done, because financial year is ending, money will be lapsed, that sanction will go. Sir, please hurry up. You say nothing is happening. Take your time. So the court takes its time. Then you give back the money without the permission of the court.
Informed also.
Whom? Whom?
Sir,
Whom?
in the next paragraph, I should. That we for information from instruction.
Where
from
is it?
finance department.
Well, what date letter? Letter dated?
Letter, 30th March.
Where is it? Is it part of the record?
So we have filed an affidavit, not in record.
Huh?
We filed an affidavit. I think clear because I also filed affidavit, it is not in record. On 2026 in a second figure, which was mentioned, that the second, stuff from the finance department regarding the exemption of the farmers.
It is to be noted that the amount will remain in the accounts of so and so, will not be lapsed after expiry of financial year 25-26.
Yes, my lord.
The second
Then-
figure was it, a letter dated 6/2026 was written to the finance department. Government of Assam seeking instruction for the utilization of the above mentioned amount, and the reply from the department is yet to be received. Action will be taken as per the instruction received from the government of.
So you want to say that first you are saying that it will not be lapsed, and then you are saying that, okay, on instruction it may be lapsed. That is the impression sought to be given.
The amount was in our account, Lordship.
Ah.
So we want clarification from the government.
Huh?
What to do.
So why did you make a statement that it will not be lapsed after 25, 26?
30 to 20, the amount is in our account.
Huh, so why the statement that it will not be lapsed?
On that day, it was not the so on that particular day.
If you had said that the amount is with me, the amount is in my bank, I have asked the department for instruction, and I don't know if they want, I will have to give back. If they don't want, I will keep it in my account and give the money. That is not the stand. Money is with me, it will not be lapsed. I have asked them, but money is with me, it will not be lapsed. Don't worry. What is the impression given?
The government, the money has been given by the finance department.
Why did you not inform the court that they are wanting it back? Why was it given back? Why was it given back without asking the court?
There is the order, it also can have a affidavit also, but the not a record can
Order of whom?
order of the finance.
You have told the court that the money will not be lapsed. So finance department tells you, you give it back in a day. Yes? When the finance asked you on 25th, you gave it back on the 26th, if you remember correctly.
Correct, my lord.
If I remember
Yes,
correctly, I have not
absolutely.
read anything else now. Immediately.
Immediately give, my lord.
Not even inform the court.
No.
Yes. What kind of why the games with the court? Why games with the court?
The commissioner secretary,
Commissioner Secretary, Finance Department.
Huh?
Telephone.
Is he your immediate controlling officer? No. Did you tell him that I have made an assurance to the court? Sir, I have made an assurance to the court. Money will not be lapsed. I should tell the court first, sir, give me 1 week. Give me 1 day. Let my counsel just inform the court that the money is going away. I will not be able to control the situation. Because of your official position, as what? As the CEO, we trusted you. When you say that money is not going back. This court trusted you. Yes?
actually, there's not intention.
What is not intention? So why did you tell the court that the money is not going back? Everybody knows the money is going back.
During the end of financial year
Huh?
26.
When will it lapse?
So it was still here.
Wh-
Till 25th of May, it was there. Only after receiving of the second paragraph of the.
Sir, we like to go very straight. Turning on my own axis, I don't like it at all. If I try to go round and round on one axis, it does not take me anywhere. All energy lost and I'm not going anywhere. You told the court this money will not lapse on the expiry of the financial year. It will not lapse. On what ground was it called back by the commissioner of the finance department? On what ground? Why did he call the money back? Because it lapsed. Yes? Because it lapsed. Therefore, it was called back. Let us understand it again. Why did the commissioner ask you to give him back the money?
All the unspent amount.
Becomes what?
Whatever was
That sanction has to go back. Why? Because the sanction lapses. The sanction to use it within that financial year, it ends. There is no further sanction. So the money has to go back, yes? If it is like that, so when we say the money lapses or the sanction lapses, it ends. That sanction is for a particular year, is it not? That this sanction is valid till so and so date. Yes? This money is given to your account. Use it for this. Sanction valid till so and so date. Yes? You told the court, no, sir, it will not lapse. Now they are hungry at home. What to do? You did not tell the court.
Now I have already been transferred from the department and they are only for 3 months.
And so you gave it back.
Given for 4 months. pending salary for 4 months from their own source.
We are understanding that now that you have given an assurance to the court that it will not lapse and it has lapsed and you gave it back to the government. Tell us, how do we get it back from the government now? From where will we get it back? You have filed an affidavit. Have you, do you have a copy of the affidavit, sir?
Yes, my lord, they have several.
Unfortunately, officially, we do not have a
Yes, my
copy of
lord,
that
he
affidavit.
told me today morning.
Which one was it?
He has filed and.
You have given us 2 copies. So these 2 are not on record. Let this come on record. What to do? Now, your claim for that payment, from where is the money coming now? Who will pay?
That is the, my lord, the current position and that's the
Who has to pay
difficulty.
now?
Wait.
Cabinet decision is clearly.
What?
Regarding the, we have to pay our salary, the employees, the ASMB, from our own source.
When are you creating sources now?
Already we take steps for creating the sources.
What steps?
My lord,
What
my lord,
steps?
may I?
The e-permit and acceptance. E-permit
E-permit?
for collection of market fees acceptance. And to
এখন তো
give the, our asset in lease acceptance.
খুলে
To collect money.
মানে আরো কেস
We already take steps for regarding for collection of money from own source.
But this is contempt, na? That money was required to be retained.
Yes, my lord. Since 2024, my lord, this money was definitely with them. They could have
Where
received,
is that? Where is that, this thing?
my lord.
Where is that order requiring them not to?
Yes, my lord. My lord, there are 2 orders. One order by way of which, my lord, this court has given a direction to create a separate account that is order dated 7/3/2026. Yes, my lord.
Huh?
Order dated 7/3/2026, my lord.
Let his affidavit come on
Yes, my
record.
lord,
We'll
that will be better, my lord. And in so far as, my lord, the clarification they have given, my lord. They have-
16 July.
Yes, ma'am. The clarification which they have given and have perused, my lord, they are trying to shift the blame to the Commissioner of Agriculture and basically to shift the blame on Finance Department without giving any clarity to the point which my lords have correctly placed.
Mr.
I mean to say, my lord, they have not given anything in that regard. That is a big
No,
vacuum
Mr.
on their part.
Prama, it is like this.
And it,
I
they have-
just said, I don't want to go
Yes,
my axis round and round.
of course, my lord.
Let the documents be here.
Yes, my lord.
And by that time, perhaps they will have some money in hand.
Hopefully, my lord.
Hopefully, also we are going to.
But that part we are going to take very seriously.
Already,
No, see, once he does not listen to the court and he gives a false assurance,
My lord.
that aspect has to be looked into.
Hmm.
These are what prima facie. I'm not saying that this is the view I'm taking,
Hmm.
but this court has a feeling that delayed somehow money goes back and everything can be settled. Just don't get a stay order. Just don't get a stay order. That is the feeling.
And that is happened.
What is reflected here?
Correct, my lord.
Money will not go back. Don't worry. No second required. We are not required to keep the money. Just don't get a stay order. We'll see what happens. Jo hoga dekha jayega baad mein.
Bas,
That attitude is
that
what
attitude
we
is
are-
wrong, my lord.
We have communicated the final.
No, my lord. What
You
we are
have
trying to say is
communicated, but
totally
you
wrong.
have made a very specific statement that the money is not going anywhere.
And that too
And
after.
therefore the money was not, the other part of the money was retained
Yes.
in a separate account, is it not? One part was retained, if I remember
Yes,
correctly.
yes, my lord.
But the crores went back. 17 should have gone back. Crores should have been retained.
My lord, one aspect is there, my lord, I may not place. In fact, just to put before your lordship, my friend has on the last occasion said that the 17 lakhs was kept intact for the other petitioners in pursuant to this court's order, my lord. Now, after going through the Chalan, wherein, my lord, the money went back, the entire money, 9 crore 75 lakhs, clearly indicates that the entire 9 crore 75 lakhs was returned. Now, the question remains, my lord, from where 17 lakhs they have kept? Because if, see, my lord, kindly, lordship, that is one aspect I will bring on a record, my lord. Because that is another place.
Bring it on record. We are fixing this on 24th.
Yes, my lord. Your lordship will see this money returned for the entire amount from where
But entire nine,
And
nine,
entire amount was gone.
75 lakhs.
That's what direction of the final, then we send back to the.
Where is the 17 lakhs?
Then we,
7 lakhs is still.
is separate from this.
Cannot be. How can
Was
be
it a
different?
part of this money or was it a separate money from this?
Of this money, my lord? Court has clearly given.
Then let him explain.
One example, and after that, after the court order, we have kept the penalty in a separate account as directed by the court. So,
That entire amount of 9 crores 75 lakhs. It was in one account. Then you took away 17 lakhs and kept it in another account. Then you gave the government 9 crores 75 lakhs. After taking out 17 lakhs, so from where did you get the 17 lakhs?
My lord, they have blatantly violated this order at this stages, my lord.
Mr. Buragohai, let us not do it
Yes,
today.
my lord. I'll not comment anything on this. my lord.
He's stepping in quicksand.
Yes, my lord.
That is all I will say. He's stepping in quicksand. Very poor. Sir.
It was a simple.
I have paid the salary.
They are very obliged. They are very obliged to you, and so is the court. Very happy that you have done it. We are not finding one fault with it. We appreciate that you did your best, but the false assurance is again coming back.
I apologize.
Let us see. We'll have your affidavit on record on the next date. You need not be personally available. We'll decide on the next date after we go to the affidavit whether his further appearance will be required, because he is yet to explain why he gave it back without informing the court. List again on the 24th of July along with the affidavits stated to have been filed. Mr. H. Buragohai prays for the opportunity to bring on additional documents by way of affidavit. Full stop. The same, if any, be filed by 16th of July 2026. Full stop. The personal appearance of Mr. Your name, sir? Atul Chandra Pathak be another personal appearance of Mr. Atul Chandra Pathak, erstwhile CEO of the marketing board. Earlier he was erstwhile CEO, ERSTWHILE, erstwhile CEO is dispensed with on the next date of listing. Full stop. The further appearance will be considered after perusal of the affidavit stated to have been filed. We have fixed it on 24th of July. Yes.
I'm obliged, my lord.
Item 11.
11 to 12.
Mr. Gupta, someone has passed DLED. Some person has passed DLED with a certain roll number. He wants the name corrected. He says the name is wrong.
My lord,
On the certificate.
photo is wrongly.
Photo is wrongly printed by you.
My
Print the
name,
correct
my
photo and
father's
give
name
it to
is
him, please. Huh?
That I'll have to take instruction.
You were taking instructions from 2024 onwards.
After 24, it has come on 26.
All the more reason you should have completed your instructions. Huh? Correct mark sheet with correct DLED certificate in the name of the petitioner. No one else can help him, only you can. Either you give it to him or we decide the issue.
I will have to take instruction.
Do you have a copy of the writ?
No.
Heard Mr. A.R. Sikdar, learned counsel appearing for the petitioner, and Mr. H. Gupta, learned CGC for the respondent number 1 and 2. Mr. Talukdar appears for the respondent number and someone appeared for the others.
4 and 5, my lord, we served copy Dosti service, but it is not-
The respondent number 4 and 5 have been served to Dusty by the petitioner, and the affidavit is also on record, full stop. The order dated 13/9/2024 passed by this order records as follows. Okay, para 2 dibo, para 3 dibo, para 4 dibo, full stop. Mr. Gupta on the next date of listing shall have his instructions in the matter and also file his affidavit if so required, full stop. The matter is of 2024, full stop. The learned counsel for the petitioner has also agreed to supply an extra copy of the writ petition upon Mr. Gupta to have his instructions, to facilitate him to have his instructions. This is the matter again on the 31st of July, 2026.
Lord, in this case, my lord, I pray for little accommodation for today.
Right? Be your name.
And in fact, my lord, they have also not filed affidavit.
Yes.
There is an interim order, my lord.
Elementary. What is the relief you seek?
I am challenging my lord departmental proceeding. Already stay, there is an interim order also. In the meantime, my lord, disciplinary proceeding is still.
Oh, the discipline proceedings under stay.
They have not filed affidavit. I am also under suspension.
If you keep a rope in water too long, it loses all strength. Mr. B. Talukdar, learned counsel appearing, learned standing counsel, elementary education department has sought for an accommodation to file the response to the writ petition, full stop. It is observed that the disciplinary proceeding against the petitioner has been kept in abeyance by the order dated 28/2025. Full stop. Accordingly, list this matter again on 5th of August 2025, by which time the parties would be at liberty to exchange their pleadings. Full stop. Interim order passed earlier continues.
Item 15. The correction, madam. Page 13. The cement line, madam, from the post of ASIUB to post of SIUB. The S should be omitted.
Mr. S. Bhattakur, learned counsel appearing for the applicant has submitted that in the order dated
25/5/2020.
passed in WPC number 4286 of 2025, this court had recorded as follows. Para 13 to the The learned counsel for the petitioner has submitted that the petitioner was required to be considered for the promotion to the post of SI within bracket B or UB and not ASI within bracket UB. Good stuff. The learned counsel appearing for the respondent authorities, Mr. Chakraborty, I know that. Chakraborty has submitted that it would amount to the correction of a typographical error, and he has no objection to the same. Accordingly, the paragraph 13 of the order dated so and so passed in WPC number so and so shall be read as follows. ঠিক আছে? ইয়াতে মই পেন্সিল দি মার্ক কৰি দিছো, এই নীলা পেন্সিল দি আন্ডারলাইন কৰি দিছো হা, আৰু এইটো কাটি দিছো। বাকি প্যারাগ্রাফটো একে থাকিব, খালি ASIUB to the post of SI হৈ যাব, এইটো গুচাই দিব। This order will be read as a part of the order dated so and so passed in WPC number so and so I disposed of. Typographical error correction is IA or miscase? It will be an IA or miscase.
For substitution,
Interlocutory is
for substitution, there is a notification.
For substitution only, it should be a miss case.
Okay. This is
Item 16.
16. Yes, sir.
Wait, please, Lordship.
Hmm?
Lordship, here I am filing this petition for implement to respondents, Lordship.
Who?
Lordship, one is Director, Lordship, Director Technical Education,
Hmm.
and other is Director Employment and Caste Maintaining, Lordship.
Heard Mr. D. Mohanto, Learned Counsel appearing for the petitioner. Also heard Madam for the Department of Health. Department of Health and Family Welfare, full stop. Ms. Bora for the Department of Health and Family Welfare, full stop. The learner count, this IA has been preferred, praying for the liberty to impede the opposite parties number
6 and 7.
6 and 7 as respondents in respondents number 6 and 7 in WPC number 7, so full stop. The learner counsel for the petitioner has submitted. I have a petitioner. The learner counsel for the applicant has submitted that that this would not allowing such a prayer would not materially affect the writ petition on merits.
Right.
However, without the presence of the aforesaid respondents, a proper adjudication. No. However, allowing the implement of the aforesaid respondents would make the adjudication feasible. Full stop. The learned counsel appearing for the respondent authorities do not object to the implement. Full stop. Accordingly, the prayer for implement of opposite party number 6 and 7 as respondents in the writ petition is allowed. Full stop. Interlocutory application is accordingly closed. Is allowed. Close no is allowed. Writ petition from Likibo heard Mr. D. Mohanto, heard Ms. Bora. By today, by an order passed in IA 20502026, so and so and so and so. 6-7 have been implemented as have been directed to be implemented as respondent number 6 and 7 in this writ petition. Full stop. The learned counsel for the petitioner will what do you say?
Title, amend the cost.
Will furnish amended cost title to the registry within a period of 3 days from today. Full stop. By serving extra copies on the counsel for the respondents. Full stop. The learned counsel for the petitioner shall also take steps for service of notice of the pendency of this writ petition on the respondents newly implemented. Full stop. List again on 29th of July 2026, allowing the respondents to file their response in the meantime. Yes.
Item 17.
Well, 17 to 20 are similar matters, Malaf. In
Hmm.
item number 70, Malaf, the Dusty service affidavit has been filed and Malaf, the service is complete. Well, these are matters relating to Malaf provincialization. Well, these persons were left out of provincialization in 2021 because their MA degrees could not be verified at that point of time. Subsequently, these were all verified and that part is over. But then it has been lying there since thereafter without any progress.
Don't say that. You're not obtaining an instruction cannot be the you have not received. You can say you have not received. If you don't obtain it, can we help you? The petition heard Mr. M. Dr. Learned Senior Counsel assisted by Learned Counsel appearing for the petitioners. Full stop. Also heard Mr. A. Art of Builder, Learned Standing Counsel, Higher Education Department. By the order dated 162026, notice was issued in the matter and the petitioner was allowed to take steps by Dusty on the respondent number 4 and 5. Full stop. An affidavit has been filed on 17/6/2026 stating the status of the stating that the Dusty service on the respondent number 4 and 5 have been completed by the petitioner. Full stop. All the others you will represent? Mr. Soliha appears for the finance department. That is the respondent number. Respondent number 2. Full stop. Mr. A. Wilder represents respondent number 1, 3, and 4. No, 1, 3, 4, and 5.
No, only 1 and 3.
1 and 3, why? 1 and 3, full stop. List this matter again on 28th of July 2026, by which time Mr. A. Wilder shall have his instructions as to why the case of the petitioners have not been taken up for consideration for provincialization, even though their educational qualifications are now stated to have been verified. Full stop. He shall also inform the court as to the time required for completing the verification and completing the consideration of the petitioners for provincialization, if the same has not been done till now. Give us a time frame. You can dispose it today also, giving you a time frame. Your choice. Yes.
Item number 18, my lord. The justice 18 justice service, my lord, has been, my lord, affidavit has been filed today. It's not on record.
Okay.
But my lord, the office note says that though the ID cards have not come back, but the postal, my lord, the endorsements shows that, my lord, this has been served, my lord. That's the office note, my lord.
I to heard Mr.
On the
M.
private-
Dr.
on
Learned
the
Senior Counsel,
principles of the college.
assisted by Mr. Deka, counsel for the petitioner, also heard Mr. Yato Wilder, counsel appearing for the respondent number 1, 3, 1 and 3, full stop. The respondent number 2 is represented by Mr. Choliha, standing counsel, Finance Department, full stop. The office note dated 18/6/2026 reflects that the postal track records, postal consignment reports indicate that the notices have been delivered on the respondent number 4 to 7, full stop. Accordingly, notice on the respondent number 4 to 7 is deemed to be complete, full stop. Let's this matter again on 28 December, 28th of July 2026. Mr. Tohbilder shall have instructions. It is a close.
July.
Last part. It is the same here.
Same.
Verification. Hey, okay. Why their cases have not been considered for verification? Jikini close. Hekini ako bhai dibo. Ha? That on next paragraph. Kiman dinot koribo hetu bhai.
Well, item number 19 also similar, my lord. Justice service affidavit is filed today, not on record.
Oh,
And-
tata likhibo. Mr. Doctor has submitted that the affidavit showing the justice service of justice notice on the respondent number 4 to 7 has been filed today. Full stop. We are going by the office note.
My lord.
19 also that.
19 also similar, my lord.
And 20?
20, my lord, respondent number 2, inadvertently notice was not issued, my lord. The finance department. It was left out, my lord. Of course, in this case, justice service was not, my lord, there, my lord.
But otherwise it is complete.
No, well, that office note doesn't say it's been completed. my lord.
It would give item number 20 dibo.
Did.
And Mr. Doctor Ekinte eke thakibo ha. Mr. Soliha, A. Soliha appears for the respondent number 2. From the finance department. Full stop. Petitioner to serve an extra, serve requisite extra copies on Mr. Choliha from a learned standing counsel for use. Full stop. And upon who are the rest of them?
Rest of the principal of the colleges, my lord. Here,
Awaits list again on 28th of July 2026, awaiting report of service of notice on 4, 5, 6, 7, and 8, full stop. The petitioners would also be at liberty to effectuate service of notice by Dusty, processed through the registry of this court, and file affidavit in that regard before the next date of listing. Kindly have that instruction when you can finish the consideration. This way, that way, do it. Huh? 6 numbers of headaches will be gone from your table. Yes, item 34.
Which legal আছে?
Miss Kotoki was, yes, Miss Kotoki.
This matter. On December 26th of December 25, we have already given an intimation to the petitioner. And I'm here.
After that, we have concluded our part, then we sent the report to the APSC. APSC rejected our day, and now already the ministry has changed, so now we have, that's why we have.
How can there be change in the ministry affect the
That,
implementation of the order of this court?
no, during that period, we are not able to modify our order, that's why there's an approval for appraisal of the departmental, it was delayed.
What is that? Kindly see, what is the order? Page 12. Please see page 12. Are we on the same case? Contempt case number?
74.
What is the order?
Order was.
Tell him what is the outcome of the DP.
Yes, outcome of the DP, but you are not, I have to read.
And this
We need only 1 month time for.
annexure 2, annexure 2, annexure 3, and this annexure 4. All of that you are treating, you are naming people. Or should it be the honorable court? Please see annexure 4. With respect to the subject cited above, this is a reminder concerning the order passed by honorable court on so and so. Then why the names? Should it not stop there? No. You had sent it to the APSC.
Yes.
APSC has rejected that prayer, that punishment. Then what happened?
And now.
What is the change of the ministry got to do with imposing a punishment?
For appraisal of the, we are the departmental ministry.
Then whom will he make an appeal to? Then whom will he make the appeal to? If you are getting approval for everything from the highest of the hierarchy, once you punish him, he has to make an appeal. Already the appellate authority has gone through his file.
We need only 15 days to pay.
15 days time. Miss M. Protocol Learned Counsel appealing for the petition, for the respondent number. For the respondent number?
Both.
For the both the respondents has submitted that has prayed for an accommodation for 2 weeks. Full stop. She has submitted that although the conclusion of the disciplinary proceeding by imposition of adequate punishment had been taken up by the department, due to certain developments thereafter, the matter is under reconsideration. Full stop. Accordingly, place this matter again on 31st of July 2026, by which time the respondents shall ensure compliance of the orders of this court. Yes, sir. Anything you found out in 1 and 2, all this?
Yes. Lordship, these are the connected cases. I found that regarding the similarly situated person, those are applied for promotion. These petitioners, those are
Want to dispose of it,
one already disposed. Regarding 2, Lordship indicated
I don't know, WBC 3
link cases, several link cases. Several, there are, Lordship, total 15 cases shown in that list. What happened, Lordship? That during the pendency of this case, the petitioner's case, others petitioner also filed the similarly situated case. And their grievances is that they were not sent for promotional training course for different regions, Lordship. And thereafter, Lordship, in several cases, they withdraw their petition.
Okay, so we can dispose this of without affecting the other cases?
Yes, Lordship.
I can
Yes,
dispose
yes,
of
yes,
this
yes,
case
Lordship.
without
Yes,
affecting
Lordship,
the other
because
cases?
Their cause of action
Very
can
well.
be different, but similar.
None appears for the petitioner on call. Full stop. Mr. Goswami Learned, additional senior government advocate, has submitted that the prayers made in this writ petition were against the impugned decision of the Departmental Selection Board not to consider the case of the petitioner for confirmation of his service in the rank of sub-inspector within bracket UB. Full stop. The learned additional senior government advocate has also submitted that the petitioner was aggrieved by the non-consideration for being deputed to the pre-promotion cadre course training for promotion to the rank of inspector within bracket unarmed branch. Full stop. The learned additional government advocate additional senior government advocate has submitted that by the orders of in compliance of these orders of the court, the petitioner has already been sent for promotion course. Is it?
Sub-inspector.
Okay. He submitted that the petitioner has already undergone the promotion course for SIUB. Full stop. However, his confirmation in the rank of sub-inspector within bracket armed branch cannot be done at this stage since prosecution for sanction. Since sanction for prosecution has been granted by the competent authority to proceed against the petitioner in connection with Dhula PS case number item 1 লিখিছিলো Dhula PS case number হেতু এলাকা নিয়ে নিব হ্যাঁ Dhula PS case number so and so and 18 of 18 and is there disciplinary proceeding also?
Yes, Lordship, yes.
The disciplinary proceeding against the petitioner is also pending. Full stop. Therefore, at this stage, the respondents are not in a position to consider the petitioner, consider the confirmation of the petitioner in the rank of SI within bracket UB. Is there any stay on the DP? Any stay on the DP?
No, Lordship, that was withdrawn.
Withdrawn and has not been filed again.
Therefore, no.
The learned additional senior government advocate has also submitted that the writ petition filed by the petitioner, wherein the disciplinary proceedings against the petitioner had been assailed, has already been withdrawn by the writ petitioner on
16/10/2025.
full stop. It appears that the petitioner, that the prayers in the made in the writ petition cannot be granted in view of the pendency of the disciplinary proceeding as also the sanction for prosecution granted against the petitioner. Full stop. There is no, in the absence of any representation on behalf of the petitioner, this court closes this writ petition without further adjudicating the prayers of the petitioner, save and except observe that during the pendency of a disciplinary proceeding and a criminal proceeding against the petitioner, the respondents would be correct in not considering him for confirmation in service. In view of the orders passed in WPC number, WPC accordingly close to you. In view of the orders passed in WPC number 3279, no, what was this? What was the prayer in this IA?
The IA.
No further orders are called for in this interlocutory application. full stop. In any view of the matter, due to the involvement of the petitioner in a criminal case and also in view of the pending departmental proceeding against the petitioner, the prayer made for consideration of the case of the petitioner for promotion to the next higher post of inspector within bracket UB cannot be granted by this court. Full stop. Accordingly, I is closed. And thank you.